and we will do all the things. All right. Good morning and welcome to the Joint Standing Committee on the Environment and Natural Resources. It is Monday, March 8th, and we are assembled electronically today for the purposes of inviting public comment on legislation, particularly for LD 489. Before we get started, I just want to share some information related to the fact that this meeting is being conducted in an electronic format. It's being live streamed on the committee's YouTube channel. That means anybody who is a participant in this meeting via Zoom can be seen and also heard if their microphone is unmuted. People on the Zoom meeting waiting to testify cannot be seen or heard until they are called upon to speak and brought into the committee's space on Zoom. So you'll move from attendee to panelist when you are invited to speak. This meeting will be recorded and available to view on the committee's YouTube channel after the meeting has concluded. At this time, we will go around and ask committee members to introduce themselves. Representative Bell, we'll start with you.
Good morning, Arthur Bell, House District 47 here in Yarmouth, and also represent Chebique and Long Island. Good morning.
Good morning. Representative Ziegler.
Good morning. I'm Representative Paige Ziegler. I represent District 96 in Waldo County, the 7 towns of Belmont, Liberty, Lincolnville, Mount Morrow, Palermo, and Searsmont.
Representative Dudera.
Good morning, everyone. I'm Vicki Dudera. I represent House District 94, the people who live in Camden, Rockport, and the island of Islesboro.
Representative Gramlich.
Good morning. Thank you, Senator. My name is Lori Gramlich, and I represent House District 13, which is the lovely seaside community of Old Orchard Beach. And I might add, I will be having to leave momentarily to present a bill in another committee on another Zoom call.
Great. Thank you. Representative Bloom.
Good morning. I'm Representative Lydia Bloom. I represent House District 3 in York.
Representative O'Connor.
Good morning. I am Beth O'Connor. I represent the individuals of House District 5, which is Berwick and part of North Berwick.
Representative Johansson, welcome.
Good morning. Chris Johansson. I represent House District 145, the 18 organized towns between Bridgewater and Sherman. I'm going to be in and out today because I'm presenting a bill in inland fisheries. So I'll see a blank face while Zooming somewhere else. Thanks.
Thank you. Senator Carney.
Good morning. I'm Ann Carney. I represent Senate District 29, which is South Portland, Cape Elizabeth, and a little bit of Scarborough. And I'm very happy to be here this morning.
And my co-chair, Representative Tucker.
Good morning. My name is Ralph Tucker. I represent half of Brunswick. That's House District 50. Thank you.
And I'm Senator Stacey Brenner. I represent the other part of Scarborough from Senator Carney, all of Gorham, and some of Buxton, Senate District 30. And we're also joined by Dan Tartikoff, who's our OPLA analyst, and Sabrina Carey, who's our clerk. And I believe in the afternoon we have a transition between Dan Tartikoff and Deirdre Snyder, who's our other OPLA analyst, who will join us for the work session in the afternoon. We are going to move into a short discussion with Dan on how the new database, I guess we'll call it, or how do we refer to it?
For lack of any better term, we're calling it the electronic LD file. So those of you on other committees may have already heard about this, but our IT department has been working for some time to create something that electronically approximates what everyone's used to having in an LD file. In other words, having all of the information on an LD file in one place. And so that is operational and ready to go, and we're going to be transitioning. All committees will be transitioning to use of that electronic LD file in the next week or two. which means, and I assume this is good news for most people, that we're going to be discontinuing sending all of the LD emails to your legislative emails. Fair, that seems like it's good news. So I'm going to very quickly go through how you access that, and I'm going to do a screen share. Oh. All right, let's see. That is not what I meant to share. Can you see the legislative website? Yes, okay. So this is legislature.maine.gov. This is the basic website to access all of the legislative information. If you click on committees, which I assume most of you are familiar with how to get to the ENR page, and then choose Environment and Natural Resources. This is going to be the quickest way to access the information for today. So you'll see on the calendar here, there's March 8th, 2021, public hearing work session, and lists all the items here. You'll see next to public hearing, there's a document icon. You click on that document icon, it's going to take you to what we're calling the electronic LD file. So the system is based on the date of the public hearing. So you're only seeing here LD 489, which is what we're having today. So it lists the LD here, and then it will give you a list of, which is sortable based on each item in the list here, of all the people that have registered to speak. So it will tell you if they're speaking or not, or if they've just submitted written testimony. If they are speaking only, not for written testimony, it will indicate the position that they've indicated they're taking on the proposal. It will provide their name, and if they're associated with a group, it will give you the group, or if they're just a member of the public, it will tell you where they're from. It will also tell you the submission date, so you can sort it by submission date, sort it by name, you can sort it by position. Next to anyone's name who's submitted written testimony, there'll be another one of those document icons. So you can see Senator Bennett submitted testimony here. You can click on that icon, and it will bring up a PDF of his testimony. And so you'll be able to access all of the testimony here and see who spoke at the public hearing as well. The way you can access this, because it's a little cumbersome because you have to be on the public hearing date, what we're going to be moving to is at the top of the ENR page, you'll see a link for committee materials. This is the OPLA Manage webpage. If you click on the committed materials page, which the easiest thing to do is just bookmark this, you'll see there's a grouping for meeting materials by LD, and that'll bring up a list of all of the ENR LDs. As the system is implemented, we will be linking directly to the electronic LD file. So for example, 618 is a bill that we were recently referred, and you'll see there's a link for the electronic LD file. And if you click on that, it will take you directly to that file. There's nothing here yet because the testimony hasn't been, oh, there's testimony here, I guess. So this is a bill we're hearing next week. Testimony's been submitted, and you can see one piece of testimony and one person that registered to speak without testimony. What we will not be doing is, at this point, we're not focusing on filling in this information going backwards. If we have time to do that, we will. But because everything is based on the public hearing date, in order to access the LD file, the electronic LD files, you would have to find the public hearing date. So here's the date we heard LD 8 and LD 203. So I'm just trying to illustrate here that the other item we will be doing is OPLA documents are going to be posted going forward in this electronic LD file. So the file will contain all of the testimony submitted by any members of the public or agencies on a bill, at the public hearing, before the public hearing, at the public hearing, after the public hearing, as well as all of the information submitted by the OPLA analyst. So you can see here, just as a test, I've posted the bill analysis from OPLA. And if you open that up, you'll see that the bill analysis from that bill is there. So it's going to be a bit of a transition over the next week or two, but ultimately that's our goal, is to have all of the information in one place where you can access it easily. I know that was very quick. I have another document that that explains this in writing with some screenshots, which I'll send around, especially for anyone who wasn't here. And I know we have a lot of people waiting to speak, but I can answer any quick questions if anyone has them.
Any questions for Dan? Are we excited about this? Great. Other little note of housekeeping, we do have a long public hearing given the number of folks that are registered to testify. So I do suspect a short break in the middle of the public hearing. And then we do suspect that we'll take a short lunch between the public hearing and the work sessions this afternoon. And for the purposes of our attendees in the meeting who will be testifying, we're going to be limiting testimony to 3 minutes today. And I've asked Representative Dudera to be our timekeeper. So she's going to keep time and she'll put up her timer and let everybody know where they're at in their testimony. And if you're in the attendee space planning to testify, please make sure that you rename yourself on your square with the name that you registered to speak with, so that we know that you are indeed here and you are who you say you are. So if you're listed as iPhone 6 or Dad's laptop, make sure you change your name. And when we do move you over into the meeting room to testify, it will feel like you've been disconnected. But if you hang on for just a second, you'll reappear and you'll be a part of the meeting space. And again, as always, in our new style of legislative gathering, we ask for your patience and your humility as we all learn together. The use of the chat function will be limited to just logistical purposes, so nothing substantive about any of the legislation we're talking about should be shared in the chat space. Okay. And at this point, we will go ahead and start the public hearing for LD 489, a resolution proposing an amendment to the Constitution of Maine to establish a right to a healthy environment. And our sponsor, Senator Maxman, is here. So we'll move her over and let her introduce the bill. Welcome, Senator.
Good morning. Okay. Senator Brenner, Representative Tucker, and honorable members of the Joint Standing Committee on Environmental Resources. My name is Chloe Maxman. I represent Senate District 13, which is all of Lincoln County except for Dresden, plus Washington and Windsor, 27 towns in the Mid-Coast. I am very honored and excited to introduce LD 489 today, the Pine Tree Amendment. A lot of people ask me why I ran for office, and I always give the same honest answer. I love Maine. I've spent my life in Noblesboro, and I love our way of life, my community, our kindness, compassion, and commitment to each other, regardless of party or background. I love our woods, rivers, lakes, oceans, dirt roads, and trails. I was raised outside on a farm, and I've known since I was little that fighting for this place is my purpose. As I grew older, I began to understand the many ways that our state is threatened. The Maine that we know and love today is no longer guaranteed to be there in the future. A major example of this change is our environment. I don't need to go into all the facts right now about how our environment is changing, but we know that things are changing for the worse. These changes are not only devastating because of their environmental impacts, they threaten our entire economy. The livelihoods of fishermen, farmers, foresters, guides who rely on a healthy environment to make a living are under deep threat. This isn't just about our natural resources, it's about standing up for our economy and our constituents. For my entire lifetime, I have watched the government stand by and do far too little to protect our state's resources, the foundation of our economy. For years, and some might argue even decades, state and federal governments have allowed the climate crisis and environmental degradation to run rampant. These problems have only gotten worse. Who pays the price for government inaction? We do. My constituents do. It is not okay. So I ran for office, but when I got elected, I was stumped about what kind of legislation could match the profound economic and environmental scale and scope of the challenges that we face. We can introduce a bill, but it only helps a small part of the problem. And in recent years, we've all seen how quickly a new administration, a governor, or a president from either party can quickly and drastically change policy courses. This political landscape is and always will be uncertain. The thing is that this uncertainty is unacceptable to me, given the huge crises that we face today. No one would have predicted that a pandemic would hit our world, but it did, and we have seen how fundamentally important it is for the government to be ready to stand up for all people, especially working Mainers. But in my opinion, our government did not live up to that expectation. We are in a situation today where we know that the greatest crises are coming our way. They're coming, and greater environmental harm and therefore greater economic upheaval are inevitable. There are numerous environmental threats to Maine right now as well. Are we prepared? No. Quite frankly, I do not trust our government to protect us in the critical years to come. That is why I am introducing the Pine Tree Amendment. This amendment adds language to the Bill of Rights of the Maine Constitution that guarantees a right to a healthy environment. This idea was brought to me by two constituents in 2019. They will both testify later today. I was immediately intrigued, and they introduced me to Maya Van Rossum, an attorney who has pioneered these kinds of amendments in other states. She will also testify later today. I began to see the fundamental importance of this legislation. The intent of this language is to hold government accountable, to ensure that all Mainers have a right to a healthy environment. No governor and no legislature, no law or permit could violate that right. This is how we protect Mainers and the natural resources that our economy will rely on for generations to come. I'm done playing games in Augusta. This is what we need if we are going to protect ourselves. I know that this idea and the language is a lot to digest. Throughout the process, I ask that you please listen to the legal experts testifying today to answer your questions instead of speculating about what this language means. There are also legal experts that I have consulted with who could not be here today, but are willing to serve as a resource for this committee. I wanted to address a couple arguments that I've already heard against this idea. There is a worry that this language could be used for one private entity to sue another private entity. Every legal expert that I've spoken with in Maine and on the national level has said that this would be a highly unusual interpretation of this language. There is also legal precedent in other states with this kind of amendment, as you will hear later, to show that this is not the intent nor the expected interpretation of this amendment. I've also heard people ask, what does a healthy environment mean? What does pure mean? Our constitutional rights are incredibly broad to best serve as protectors for the people. We have a right to free speech, a right to bear arms. These are very broad rights. At the same time, I am also very open to working with the committee on fine-tuning this language so that it is as unambiguous as possible. I have been talking with lawyers as well as some members of the House on amendments to this language, and I think that there are many ways to work together to make this a reality for all Mainers. I urge you to join me in sending this crucial amendment to the people of Maine, to our constituents, so that they can finally realize their legal rights to a healthy environment, an inherent right with which each and every one of us was born. Thank you for your time, and I am happy to answer any questions about the Pine Tree Amendment.
Thank you, Senator. Are there any questions at this time? Not seeing any. I think next up would be your co-sponsor, Senator Bennett.
Thank you, Madam Chair. And allow me to introduce myself as a member of the committee too, because I had to be elsewhere presenting another bill this morning, and I'm just joining you now. I'm Rick Bennett. I live in Oxford, and I have the honor of representing the beautiful foothills and lakes region of Western Maine in the Maine Senate. Senator Brenner, Representative Tucker, esteemed colleagues of the Joint Standing Committee on Environment and Natural Resources. I'm pleased to co-sponsor LD 489, a resolution proposing an amendment to the Constitution of Maine to establish a right to a healthy environment, also known as the Pine Tree Amendment. The proposed amendment is predicated on the fact that a core condition of human life and core to our state's identity is a healthy environment and a clean outdoors. This amendment will hold our government accountable to protect these as basic rights. The Pine Tree Amendment would be added to Article 1, the Declaration of Rights in the Maine Constitution. This enumeration of rights therefore precedes the mechanisms and applications of governmental powers, the checks and balances, the legal definitions which follow. Indeed, the expression of these rights foremost in our founding document is designed as a limitation on the governmental power that is thereafter constructed. The Declaration of Rights are the bedrock principles and legal protections that you can expect if you live in Maine. The Pine Tree Amendment fits comfortably and contentedly in this context. What commonality is more important for Mainers than our bountiful, beautiful outdoors? The clean winds of Katahdin, the lapping waves of Sebago, the bends of coastal shoreline. What says Maine more than cross-country skiing on a crisp March morning, dipping your paddle into Chesuncook Lake, feeling the earth awaken around your tree stand in November, traversing the boulders of Mahoosic Notch, or hearing the buoy bell at eventide? Our way of life in Maine demands recognition and protection as a right of the people. Sadly, our government has shown that it cannot always be trusted. Sometimes its policies are swayed unduly by centers of influence, such as globe-straddling corporations that may think of Maine as a market, as a means to an end, rather than as the unique place it is, where there is a special interconnectedness between the people and the lands and waters in which we live, play, work, and find sustenance. Thus, the Pine Tree Amendment will help safeguard the harmonizing elements of our way of life, our shared values, and our common culture. I ask for your favorable consideration and thank you for your attention.
Thank you so much, Senator Bennett. Representative Giudera.
Thank you, Madam Chair. Thank you, Senator Bennett, and thank you, Senator Maximum. I just had a question. I believe that Senator Maximum mentioned amendments, and I am just wondering, are those in the works, or were you just talking about perhaps in the future? I just want to follow up on that. Thank you.
I shouldn't speak for Senator Maxman, but since you're asking the question of me during my testimony, I'll have to say that I've participated in some meetings, which are multi-party meetings, party with a partisan side to it, as well as just multiple interested parties, where some of the language of this proposed amendment has been reviewed and discussed. Because there are, concerns that I've also read about in testimony to follow that indicate some of the words might be considered for change or amendment by the committee as we work the bill. So I think it's fair to say that this is a constitutional amendment. It needs to be carefully thought through. Every word is critical. And the committee, I look forward to working with the committee on making sure that if this is favorably voted, which I hope it is, that it comes out strong, clear, clarion bell, which fits neatly into the constitutional language that surrounds it.
Any other questions for Senator Bennett? All right, thank you so much. And I believe next up will be Representative Bill Pluker.
Thank you very much, Madam Chair. Senator Brenner, Representative Tucker, and honorable members of the Joint Standing Committee on Environment and Natural Resources. My name is Representative Bill Pluker. I represent House District 95, including the towns of Warren, Hope, Appleton, and part of Union. I'm here today as a co-sponsor and supporter of LD 489, the resolution proposing an amendment to the Constitution of Maine to establish a right to a healthy environment, otherwise known as the Pine Tree Amendment. Senator Maxman first brought this idea to me last summer. As a farmer and independent, she thought that I might bring a unique perspective to this legislation. I must say, at first, I was skeptical. I was worried about the broad implications of adding language like this to the Maine Constitution. I asked myself if this was truly necessary. Through conversations with Senator Maxman, advocates, lawyers, and experts in this issue in Maine and other states, my mind has changed. I see this amendment as an issue of rights. The Pine Tree Amendment is about preserving our rights as Mainers to clean air, clean water, and a healthy environment. As an organic farmer, I understand how important these resources are to the very foundation of Maine's economy. Yet we have no guarantee that our government will protect the environment that keeps Maine going. The Pine Tree Amendment holds our government accountable and protects these fundamental rights. For the first time, Maine residents will have standing to protect themselves from the government overreach that impacts our environment and the resources that I depend upon for my family's livelihood. There will be experts coming after me who will explain the legal implications of this language. For now, I want to lay out a few points as a farmer. First, I've heard some worry this amendment could be used as an opportunity for neighbors to complain about farm activities. Based on conversations with legal experts, my understanding is that this is not the case. This language holds the government accountable, not individuals and companies. It is extremely unlikely that a court would allow this amendment to be used for one private entity to sue another private entity. This is a tool to ensure that permits, laws, funding are in the best interests of Mainers and the environment. There are 3 examples from Pennsylvania where there's a similar constitutional amendment showing how this has been used in other states to protect farmers. The Public Utility Commission in Pennsylvania relied in part on the state's environmental rights amendments to shore up its determination that a power line should not be approved because the company had failed to demonstrate a genuine public need in the face of the tremendous environmental and economic harms that would result. A number of the farms were among the challengers to the project, including organic farmers. The farmers were concerned about the ramifications of a project on their farming practices, their safety, the economic vitality of their farms, and the ability to sell their farms given the undesirability of power lines. This amendment was used in Pennsylvania to challenge as unconstitutional a law that would override local zoning and include mandating the right to frack in agricultural districts. This protection was very important for farmers who do not want to find themselves abutted by industrial fracking, given all the water, air, and land pollution they cause. Although we do not have a threat of fracking in Maine, this is an example of how this language can be used to protect farmers. Given Pennsylvania's failure to put in place needed drinking water protections to address high levels of PFAS contamination, a legal challenge relying on the Pennsylvania Environmental Rights Amendment is currently advancing through the courts. In fact, just the filing of the lawsuit has sparked the state to act. After having learned about the Pine Tree Amendment over the past year, I feel confident that this bill is a solid path forward for Maine. This is a hallmark piece of environmental legislation that deserves our full support. Thank you for your time, and I'm happy to answer any questions.
Thank you so much, Representative Pluker. Are there any questions from the committee? Yes, Representative Bloom.
Thank you, Madam Chair, and thank you all 3 of our presenters, and maybe not just for Representative Pluker, but for the other 2, Representative and Senator, who answered. I'm asking, how do you see this creating change in statute going forward? For example, currently we have state statute in our land use regulations in Title 30A. We have state goals that includes protecting our natural resources and things like that. And it actually puts in statute these protections and encourages this from our municipalities and their planning. do you see that this will mandate changes in language throughout statute where in the Constitution?
Yeah, so the beautiful thing about this is that it is in the Constitution, that it's not in the statute, that it is a relatively so a permanent part of our framework or legal framework as a state. And so that means because it's in the Constitution, it's going to be interpreted by folks in the judiciary. And so it's not going to mandate any changes in our statute unless the judges find that our current statute is contradictory to the Constitution as we create the Constitution. And what it does is it gives standing to individuals, to people, farmers, to challenge current statute if there was a need and say, this statute is hurting me, it's hurting my business, it's hurting my community, my economy. And that's fundamentally what it does. It's not a target on any particular statute that currently exists. It just gives me the opportunity as a private citizen to challenge it in the courts.
Okay, thank you.
Any additional questions? Okay, not seeing any. We'll move on to Representative Newell. Welcome. Good morning.
Good morning. Good morning, Senator Brenner, Representative Tucker, and other distinguished members of the Joint Standing Committee on Environment and Natural Resources Committee. I am Tribal Representative Rena Newell from the Passamaquoddy Tribe at Sabayak. Thank you for the opportunity to present for this committee's consideration of LD 489, resolution proposing an amendment to the Constitution of Maine to establish a right to a healthy environment. I also extend thankful greetings to Senator Maximum and others that have brought us here today. Today, I'm going to offer a perspective for your consideration. Although the Passamaquoddy tribal citizens are guaranteed to exercise their protected rights to enjoy life, liberty, and happiness as other Maine citizens under the state constitution, for the past 18 months, I have been working with others to remediate the unsafe drinking water conditions of the Passamaquoddy tribe at Sabayak. I have included in my testimony written articles of reference that can expand upon what I have just mentioned. In addition, as a result of the limitations set upon the tribes under the Maine Implementing Act to exercise our sovereign rights to access and provide clean water to the Passamaquoddy tribal citizens of Sabayak from the lands we own has threatened our right to living healthy within our environment. It is from the above mentioned experience that I ask for you to accept this testimony in full support of this resolution that proposes to amend the Constitution of Maine, thus to grant all humans, regardless of race, ethnicity, or income, to have the same rights to clean water, air, and healthy environments. At this time, I'll be happy to answer any questions that members of the committee may have. Willie One, thank you.
Thank you, Representative. Are there any questions? I'm not seeing any. Let's see. I believe Representative O'Neill is next. Thank you so much, Representative Newell.
Thank you so much.
Welcome, Representative O'Neill.
Thank you, Senator Brenner. May I begin?
Yes, please.
Senator Brenner, Representative Tucker, and esteemed members of the Joint Standing Committee on ENR. My name is Representative Maggie O'Neill. I represent House District 15, which is in Saco. And I come before you today as a co-sponsor of LD 489, which would amend the Maine Constitution to create a right to a healthy environment. So before starting, I'll just give some background about how I became involved with the project. Before I knew that Senator Maxman was working on this proposal with folks in her area, I had actually also flagged this as something that was important for Maine. I read about other states in passing, and I was partnering with local high school students in Saco on what we could do to protect our state into the future. This fall, I bounced the idea off of the environmental law professor at Maine Law His name's Professor Maffa. He thought it was a good idea for our state, and he's agreed to come before the committee today to offer more information and to help you all think about what the amendment will mean in practice. So in my testimony, I'm going to talk about a couple things this morning. And the first is, why put this in the Constitution at all? Our Constitution is a foundational document that sets out our values and the most important rights that we want to protect. For example, right now, our Bill of Rights protects the freedom of religion, freedom of assembly, right to due process, and the right to bear arms. It doesn't recognize the foundational right to a clean and healthy environment, including clean air and clean water. Such protection is in line with our values here in Maine and essential to include among our Bill of Rights protections going forward. Here's why. Article 1, which is the Bill of Rights section of our Constitution, was drafted to protect us from different ways that government could encroach upon our rights or not do enough to protect us. For example, we protect free speech, even if that speech is unpopular, hateful, or ugly. And that's because we have decided that the free exchange of ideas is foundational to a democratic society. That's also why we protect ourselves against unreasonable searches and seizures, so that agencies can't come into our homes or search us without meeting a minimum protective standard. Speech protections and search and seizure protections create a backdrop against government encroachments. Similarly, a constitutional amendment can protect against government not doing enough to protect our interests. For example, in Maine, we amended our Constitution under a different article, Article 9, Section 23, so that any reduction or substantial alteration of public land must first be approved by a 2/3 vote of the legislature. We added this protection to guard against our government not doing enough to protect our public lands. And thanks to that amendment, right now, BPL, the Bureau of Public Lands, is facing a challenge in court for signing a lease in secret with CMP for the corridor project without first seeking the legislature's approval. That constitutional amendment is now acting as a backstop that's protecting our public lands and us. By protecting our right to a clean and healthy environment in the Constitution, we'll create a parallel backstop that protects us from something government might do that doesn't protect that right, or that protects us in situations when government doesn't do enough to protect us. It's an added check on our system. And second, what will the amendment mean for the future? The goal is to make sure that our government's decision-making process prioritizes environmental protection and pollution prevention, rather than pollution permitting and management. The amendment will fill in gaps that exist in our environmental laws. It will strengthen environmental justice. It will protect our health and our future. That future focus is really important. As you know, environmental harm comes with costs, including those related to health, cleanup, flooding or drought, decreased property values. Most often, those costs are borne by those who lack political power, such as BIPOC and low-income communities. Protecting our right to a healthful environment will mean that the government decision-making process will take this right into account and consider environmental degradation. So that means everything from creating laws and regulations to issuing decisions and permits. If a harmful decision is made, or if government doesn't do enough to keep us safe, we'll have a backstop to protect us into the future. I heard Representative Bloom's question earlier, and I'll say that it's hard to say exactly how this amendment will be used in the future, and that's why it's so important. I think that anyone in Maine would recognize that without a healthy environment, without clean air, clean water, and stable ecosystems, we'd have trouble enjoying any other rights or freedoms. Before I can engage in dissenting speech or seek to protect my home from unreasonable searches, I need to have clean air to breathe. So we propose this amendment to our Constitution because a healthy environment is essential to all else. Government has a role to protect us, and this amendment will push our state government in the right direction and create a final backstop for our most fundamental human needs. thank you for your attention, and I am here to answer any questions.
Thank you so much, Representative O'Neill. Representative Gramlich.
Thank you, Senator, and thank you, Representative O'Neill. I think Senator Maxman or Senator Bennett might have mentioned this, and I'm not remembering. Can you identify, or do we know whether or not other states have proposed similar amendments to their state constitutions relative to this issue?
Sure thing. I don't have the entire list on the tip of my tongue, but I can tell you that Montana and Pennsylvania have something similar, and that those have been a part of our conversation. We'll also have folks that are much better versed in this. And I can also tell you that New York State is in the middle of this process. Their legislature has approved it to be sent out to voters, and I think they're going to vote on it in November of this year.
Thank you very much. I appreciate it.
Any additional questions? Representative Bloom.
Thank you. Welcome, Representative O'Neill. Nice to see you. So, it seems to me, though, we're not giving Maine enough credit for the way we've done our environmental protection has been lauded as one of the best in the country in a lot of ways. And I just think that this amendment is reflective of that. And that's why it kind of makes sense for Maine, because it reflects because if you look throughout all of our statutes, you'll see lots of protections for resources and water and marshes and shoreland and all of these things that we've done a very good job of, I think. And I just wanted to recognize that. And also that, as I said, I think that, would you agree that this makes sense because of our record here in Maine?
Thanks for the question, Representative Bloom. It's good to see you as well. I would agree that we have a culture here in Maine of wanting to think about the future and protect our environment. And I think that there's always room for improvement, and there's I don't see any harm in adding this as a backstop. I see it as added security and a floor beneath which things won't go, and that's how it will be interpreted and play into the future. To close gaps, you never know what's going to come up.
Any additional questions? Thank you so much, Representative O'Neill.
Thank you. Good to see you.
You as well. Okay, there were a handful of other elected officials who had intended to swing by this morning. I don't see them yet, but we can pop them in to the queue when they arrive. And I'm not sure, and perhaps you can raise your hand if this is the case, if there's anyone who's here from DEP or from the administration that's planning to testify this morning. If you could raise your hand so we could recognize you next. If you're planning to speak, that would be helpful. Going once, going twice. I don't see any hands going up. Okay, so next up will be Anthony Maffa.
Good morning.
Welcome. Thank you for joining us.
Thank you, Representative. My name is Anthony Maffa. I'm a professor of environmental law at the University of Maine School of Law. And I'm here today in my professional capacity to first offer my expertise to the committee in interpreting and crafting the language of this bill and its underlying constitutional amendment. I'm also here to testify in my personal capacity in support of the legislation and the amendment in principle. So first, as to my expertise, to the extent the committee is holding further working group sessions on the language of this proposed amendment, or there's going to be any further discussion of it, I would be glad to provide my analysis based on my research and experience in environmental law. The constitutions of 6 other states have provisions that protect environmental rights explicitly. Those states are Hawaii, Illinois, Massachusetts, Montana, Pennsylvania, and Rhode Island. As Representative O'Neill stated, New York State is actively considering a similar amendment to the one that's before you all today. I wanted to briefly just share my reading of the proposed text in light of these similar provisions now, but I wanted to stress that a more in-depth analysis with more than 3 minutes would probably might be warranted, and I'm happy to offer that if that's something that's of interest. But the way that the amendment itself, is what I'm speaking about now, the way that I would read this is that first it provides the sort of core right to a healthy environment. That's the beginning, the first sentence, and the second sentence makes that right actionable by citizens of the state. It goes on then to describe the trustee obligations or the trustee relationship that the state has with respect to its natural resources, and then describes that the content or the sort of the way that the state will carry out that trustee arrangement in the sentence that follows. And in particular, that sentence stresses the equitable use of the resources with respect to all of the state's citizens. And the last sentence does nothing more than reiterate that this is just another of the enumerated amendments and is on equal footing with the other enumerated amendments within the Maine state constitution. As I said, that's a very brief reading or my read of the statute and the proposed language within the statute and ultimately the amendment, but I don't have time to get into to parse it all right now, but I'm happy to do that if that's something that would be of interest. Turning to my personal opinion, I support this bill and the underlying amendment because it attempts to confront the core policy challenge of environmental law as it relates to common resources, which is the collective action problem. And in particular, the incentives for any particular government of the state of Maine to address environmental harm in any given session of the legislature or gubernatorial administration are frequently misaligned. Largely, this is due to time scale, because the effects of environmental degradation are often felt by future generations of humans, where the perceived economic cost of addressing those harms are felt in the present. So put another way, oops, am I done?
Thank you. Yeah, your time's up, Professor Moffat.
Right.
Thank you so much.
Oh, that's good. I got there. One more sentence. Okay. Thank you.
Thank you so much for joining us, and hopefully you'll be able to join us for questions if we have any during the work session. Thank you. And next up, Ms. Van Rossum.
Excuse me.
Oh, you have a question.
I had a question.
There's a couple questions. Goodness, I'm rushing us along. Senator Carney, yes, please.
Thank you very much. It's good to see you, Professor Maffa. And I had 2 questions. One is, it seems like you stopped a sentence short. Could you please read your last sentence? And then my second question has to do with the reference to the state serving as a trustee of the natural resources of the state. Could you elaborate on your understanding of what that trustee relationship entails? Thank you very much.
Sure, surely. So the last thing I was going to say is that we have an intergenerational collective action problem, and the amendment's text would allow citizens to hold the government accountable for inequitable, inefficient, and harmful myopic decisions about the use of resources and the state's environment. So that was the last thing I was going to say. As to the trustee language, the way that I interpret this, and I also happen to be a professor of trust in the state, so this is right up my alley, is that it creates a fiduciary relationship with respect to those natural resources that are held in common for the people of Maine. What does that mean? It means that those trust resources, if they're going to be used, extracted, or otherwise divested from, that has to be done for the benefit of the beneficiaries of the trust, who in this case would be the citizens of the state of Maine, and consistent with the trust purposes, which in this case are maintaining our resources for future generations. And so you could, not to get too far down this rabbit hole, but you could imagine discussions of sustainable use and the yield that our resources can sustain over time so that future generations can also have access to those same resources.
Thank you.
Representative Ziegler.
Yes, good morning, Professor, and thank you for coming. I don't see a written testimony, and I was hoping that you could do that. We're going to have a lot of testimony today, and to remember the different testimonies, I would like to have an electronic written testimony if possible. Is that possible?
I was intending to submit one afterwards, so I will do that. Yes.
Thank you very much, because people my age really like a memory hit.
Of course.
Any additional questions for Mr. Maffa? All right, thank you so much for joining us this morning.
Thank you all.
Ms. Van Rossum, welcome.
Thank you so much. Good morning, Senator Brenner, Representative Tucker, and esteemed members of the Joint Standing Committee. My name is Maya Van Rossum. I am an attorney, and I'm a leader of an organization and have written an award-winning book, both of which are focused on constitutional recognition of environmental rights. With regards to the question regarding other states, at this time, there are only 2 other states with protections on par with what Maine is considering, Pennsylvania and Montana. But I am working in 10 additional states along with Maine, working with communities to advance similar constitutional environmental rights. The proposed Pine Tree Amendment that you are considering recognizes the right and the obligation of all levels of government to protect the environment, from the local town council to the state legislature. The Pennsylvania Amendment has been used to protect local zoning authority in the face of damaging fracking and inappropriate development. The amendment will ensure environmental rights are included in the fair balancing of rights that may be impacted by government decision-making. For example, if both property and environmental rights might be affected by government action, then both must be considered, balanced, and protected in the final outcome. The trust language and Article 1 placement will provide powerful benefit for environmental justice by requiring that environmental rights are protected equitably across communities, regardless of race, ethnicity, or socioeconomic status. The Article 1 placement and trust language will ensure the amendment can be directly relied upon to protect the right to clean and healthy water, air, and environments, even when there exists a gap in the law. For example, if Maine had an environmental rights amendment years ago, it could have been used to help prevent and address PFAS contamination that is now harming farming, human health, and the environment. The proposed language is appropriately written using broad terms characteristic of Article 1. And over time, as with other fundamental rights, the amendment will be defined by legislative, executive, and judicial branches of government. And the inclusion of the legally well-defined trust language is particularly helpful in providing interpretation guidance and boundaries. In Pennsylvania and Montana, the 2 states with similar amendments, the legal actions filed have been to address serious issues of public concern. For example, to protect the state from having to enforce a well testing contract that could contaminate an entire town's drinking water supply. Securing state agency to ensure responsible parties cleaned up a toxic site before considering it for residential development, and protecting natural resources from industrial gold mining that could impact Yellowstone National Park. I see I'm at the end of my time, and I thank you for the opportunity to testify.
Thank you so much, Ms. Van Rossum. Representative Tucker has a question.
Thank you very much for coming. Hello.
Thank you. Yes, I appreciate being here.
Okay. Much of the testimony so far has focused on a lack of trust in the legislative process and a failure of the legislatures to guarantee environmental safeguards. Do you have more trust in the judicial branch and that judges are better able to implement the will of the people?
So I actually don't view this as a lack of trust in the legislature, in the governor, or any arms of government at the state level. But there are limitations as to what can be accomplished through legislation, through regulation, and through implementation. There are always going to be gaps that need to be filled, either because of new technologies or chemicals, or just because the legislature can't address everything all the time to the degree that's necessary. In addition, often there are local conditions, right, that change the way a law would operate in one context or another. And so it's important to be able to address those local conditions as part of decision-making. And the trustee obligations and the language proposed helps do that. So I think that the legislature, the governor, the local town council, and the courts all have an important role to play in environmental protection. And the Constitutional Environmental Rights Amendment, the Pine Tree Amendment, just ensures that overall guidance that will make sure that everybody is able to fulfill their role in this effort to the full extent possible.
Do you have a follow-up, Representative Tucker? Senator Carney.
Thank you very much. Welcome virtually to Maine. I have a question for you. You had briefly mentioned the balancing of state interests, and I think that's a really important part of this proposed legislation. Could you please speak to how the conditions under which the balancing of state interests would arise, and how the outcome would be different if this amendment were in place versus if it were not? Maybe you could give an example. Thank you.
Yes, thank you. I appreciate the question. One of the things that the Pine Tree Amendment does, right, is place environmental rights into the Bill of Rights section of the Constitution, so it is on par with those other fundamental rights. And what we can see in many contexts, for example, if there's a development proposal or a proposal for a new industrial operation, that often the property owner will be allowed to or able to use a claim of property rights to overcome questions and concerns about pollution and degradation that might result for the surrounding neighbors. Right now, there is no co-equal counterbalance for regulators and government officials to think about those environmental ramifications for nearby property owners in the face of a claim of takings, for example, on the property front. But if you put environmental rights in the Bill of Rights section of the Constitution, the two are now on par. And government officials are not just able to, but are obliged to consider the two rights co-equally. And so that can really help ensure environmental and property rights protections for all the neighbors around.
Thank you.
Oops, Representative Bloom, I had you next, but then your hand. You're good. Okay. Representative Gramlich.
Thank you, Senator, and thank you, Ms. Van Rossum. I'm intrigued by some of what you've spoken about in terms of local zoning and municipal rights and property owner rights and the claim of taking, and particularly what's happening in Pennsylvania with regard to fracking. I'm curious if you could speak to, in your professional opinion from what you've seen in other states and certainly how this might impact Maine, the implications that such an amendment to our Constitution would have on water rights, particularly in terms of commercial extraction, and how we can continue to protect our most precious resource, in my opinion, which is our water.
Thank you for that important question. So really, I always like to make sure that everybody gets oriented when they're thinking about an important question like that, to recognize that our focus is on government actions and activities. And so when we're talking about water extraction or pollution discharge, limitations on the others of to access water, whether it be groundwater or surface water, when the Constitution is brought into play, we are looking for what is the government action or activity that's trying to oversee what is about to happen. Perhaps it's a permit. In that context, what the Pine Tree Amendment will do will be to ensure that the environmental ramifications of the proposed action or activity will result in. Again, whether it's a permit or legislation, each of these contexts are very different, but it will require a consideration of local conditions. It will require a consideration of environmental justice. It will require consideration of the ramifications for those who are around. And it will look at that in the context of existing laws, and then whether or not that overarching obligation of ensuring constitutional rights are in fact respected and protected. The constitutional review is in addition to the legal review, as well as helping to inform it. I'm sorry, I know that's a broad question, I know it's a broad answer, but it's a little bit difficult when there are so many different contexts to your important question. But if you have something in mind, maybe I can be more helpful.
And that's okay. I won't take the committee's time up, and perhaps we can connect offline. I'm particularly concerned about water extraction and the implications that has overall on folks' accessibility to clean drinking water. But I really appreciate your answer. Thank you very much.
And I'm happy to follow up with any committee members. And just in follow up, it will impact water quality as well as water quantity, or it should.
Thank you.
Representative Bloom.
Thank you. Welcome. This is Mr. Awesome. I've had your book for years. I was at the National Caucus of Environmental Legislators one year where that was there. Maybe you were there too. But I guess it's back to sort of thinking about the regulations and the statutes that we put in place as a legislature. And then so what you're saying is, if I understand correctly, that we're going to have to consider that amendment when, in addition to considering everything else that we consider when we put in environmental legislation. It requires a lot of thought. It requires balancing of monies and resources to effectuate that. Are we going to be mandating activity with this constitutional law that's going to create more need for more government to oversee it?
So the Constitution itself isn't going to be mandating any additional specific activity. What it will do is first very helpfully help legislators and regulators and even the courts and the executive branch interpret the laws that you have on the books. It will ensure that when you have those situations where those laws aren't protective enough, because perhaps you're going into an environmental justice community that's already being overwhelmed by serious quantities of air pollution or water pollution, the constitutional right will be able to help give that additional context to the consideration and implementation of the laws and the regulations that are already on the books and the permitting perhaps that's being considered. It will provide a really powerful foundation. So when the legislature wants to do something more protective of the environment, that they can ground that additional protection in the obligation to protect the environmental rights of the people of the state and the natural resources of the state. And again, in those situations where the law hasn't had the opportunity to catch up, because you have a new chemical like PFAS, or because you have a new technology like fracking, the Constitution can be used to help fill the gaps until the legislature can catch up with the needed protections. So it plays out in a lot of really different ways, but it's really all about helping to bolster and strengthen the environmental work that all levels of government in the state of Maine are seeking to accomplish.
Thank you.
Thank you.
Any additional questions for Ms. Van Rossum? Thank you so much for joining us this morning.
Thank you for the opportunity.
Have a great day. And next up, we're going to welcome Senator Daughtry. Welcome. Thanks for joining us.
Good morning. Thanks for having me. Fine to jump right in? Good morning.
Please do.
Good morning, Senator Brenner, Representative Tucker, and distinguished members of the Joint Standing Committee on Environment and Natural Resources. My name is Maddie Daughtry, and I am the state senator for Senate District 24, which includes the towns of Brunswick, Freeport, Harpswell, North Yarmouth, and Pownell. and I am pleased to be here today to support LD 489, a resolution proposing amendment to the Constitution of Maine to establish a right to a healthy environment. Here in Maine, our way of life is largely determined by our environment. Whether you're an avid outdoorsman or a registered Maine guide, a local trail runner, or just simply like to enjoy our natural resources, folks in Maine appreciate and rely on our outdoors. In addition, our economy is largely dependent on natural resources, including fisheries, forestry, agriculture, and tourism associated with outdoor recreation. These industries are under the constant threat of climate change, which has dramatically altered the landscape of our economy and the way of our life in numerous ways. I'm proud of the fact that we have substantial environmental protection measures through sound science-based public policy, but it's time to go a step further. LD 489, the Pine Tree Amendment, makes sure that the government of Maine upholds its commitment to protecting our basic rights to the outdoors, clean air, and clean water by enshrining these crucial rights into our Constitution. No person in Maine, whether today or decades into the future, should have to question their right to a clean and healthy environment. Thank you for the opportunity to speak briefly in favor of this bill, and I would be happy to answer any questions.
Thank you so much, Senator. Are there any questions?
Letting me off easy.
Delighted you took a break from education to join us in ENR.
Lovely to see all of your faces, and now back to education. Thank you so much.
Bye-bye. And next up is Mr. Brodigan. Thank you for joining us. Welcome.
Good morning, Senator Brenner, Representative Tucker, honorable members of the Joint Standing Committee on Environment and Natural Resources. My name is John Brodigan. I've been a resident of Falmouth for a quarter of a century, and I've been practicing law for nearly 30 years. In my limited time, I don't want to address all the details of the language in the resolve, and I don't want to predict how it would be applied in certain circumstances by a court or the other branches of government. Instead, I want to take a step back and view the proposal from a broader perspective. All people have certain rights. These rights are not given to us by the government. They are a natural feature of human existence, and they cannot be taken away. In other words, they are inalienable rights. These rights exist whether or not the government actually recognizes them and protects them. These rights arise out of our deep values. They are moral and philosophical truths. They are not an outcome of the legal or the political process. They come from a higher place. Now, the legislature can and often does debate good public policy, and that policy can change depending on the prevailing interest of the public and the outcome of political processes. But I believe that the public interest in a healthy environment is one of those inalienable rights in a category of its own above those policy debates. It is valuable and indeed necessary for us to secure that right for ourselves and future generations with the strongest possible legal protection in the very foundation of our government. We should give it the most durable recognition we can possibly provide. I don't believe that the right to a healthy environment trumps all other rights, but I do believe its importance is comparable to that of other rights your predecessors have placed in the Constitution, including the right to local self-government, the right to be free from corporal punishment, the right to worship, the right to not be discriminated against, the right to keep and bear arms, the right to have contracts respected, and the right to be safe, etc. This is a different conversation than those at most public hearings. The right to a healthy environment does not depend on what the government does. The issue here is whether our laws will recognize that right and fortify it with an express statement of our common resolve and give it the protection of the Constitution. One additional reason why the right to a healthy environment should be given constitutional protection is that this right extends beyond the generational horizon. It recognizes that we will be followed by Mainers as yet unborn, and they will have the same rights that we have. Our generation has no legitimate authority to do anything that reduces the rights of the next generation for our own benefit. There is also a horizontal equity value of this amendment, as well as existing income and across existing income and demographic groups. I'm confident that if you consider this resolve in that spirit, it will be clear to you that we need to do this. This is why you were called as elected representatives. If you send this resolve to the voters, an overwhelming majority will enthusiastically endorse this measure. Future generations will remember your vision and leadership with gratitude. I appreciate your consideration.
Thank you so much, Mr. Brodigan. Are there any questions? Not seeing any. Thanks for joining us this morning. Okay, next up is Andrea Verrill. And then after Ms. Verrill will be Ann Burt. Welcome.
Good
Ms.
morning.
Verrill.
Can you hear me?
We can, yes. We can't see you, but we can hear you.
Oh,
You can turn your video on if you'd like. There you go. Welcome.
good morning. Nice to see your faces. Greetings to the chairs, Senator Brenner, Representative Tucker, and members of the committee. Special thanks to Senator Bennett of my hometown in Oxford County for co-sponsoring this bill. It's a great pleasure to offer my enthusiastic support of LD 489, a resolution proposing an amendment to the Constitution of Maine to establish a right to a healthy environment. I'm a biologist, wetland scientist, and restoration ecologist that works to protect, connect, and restore our waterways and to ensure clean water, resilient communities, and a healthy environment for all species every day. I grew up in a farmhouse on a west-facing hill, surrounded by an apple orchard, acres of fields, forests, wetlands, rolling hills, ponds, streams, and springs in Western Maine. My childhood home has the best water. Often I'd come inside with the fresh air in my hair and drink straight from the faucet, knowing that the cleanliness and refreshment was ensured. And being a little bit of a wild thing, I liked that it made me feel closer with the deer I watched so regularly in our orchard. I knew the places in the woods where they could drink. It was the way life should be. But things have changed. I moved away, discovered the horrible taste of chlorinated water, and the eye-opening reality that far too many people do not even have access to this. With great sadness, I've witnessed the inequities that poor communities, Indigenous communities, Black and Brown communities suffer without access to clean water, clean air, green and wild spaces. All too often, I have concerned Mainers reach out to me to assist with protecting a wetland or water source, or to save an important neighborhood forest, only to be helpless to help them because regulations were followed, permits were granted. We live in a state where it's accepted practice to pay to pollute, but those who pay the true costs are not the ones polluting. This is not the way life should be. We need the Pine Tree Amendment to ensure that all communities, regardless of race, ethnicity, or income, have the same rights to clean water, clean air, and healthy environments, and that it will be the duty of all government officials to protect all communities equitably. We need the Pine Tree Amendment to provide the broad guidance that ensures government decision-making substantively and procedurally considers environmental impacts early in the process when prevention of pollution, degradation, and environmental harm is most possible. As someone who works day and night to ensure clean water, clean air, a stable climate, and healthy environment is ensured for all generations, I ask you to join me. Please vote in favor of LD 489. Thank you for the time and the opportunity to come before you today.
Thank you so much, Ms. Verrill. Are there any questions? All right, not seeing any. We'll move on to Ann Burt. Welcome, Ms. Burt. Whoops. Ms. Burt, you're on mute. You'll want to start over. There you go. Welcome.
Yes, thank you very much. Good morning, Senator Brenner, Representative Tucker, and distinguished members of the committee. I'm Andy Burt, and I live in Edgecombe. I'm a retired environmental program director who is now engaged in producing films about Maine people, their environmental concerns, and solutions. I'm here to testify in support of LD 489, an amendment that would enshrine into the Maine Constitution environmental rights for all people in Maine, including future generations. Here's why I feel compelled to speak. 21 years ago, our first grandchild was born 3 months prematurely. We drove through the night from Maine to meet Kelsey, who in my husband's words was the size of a red squirrel. This tiny girl you could practically hold in one hand was struggling for life. As I gently touched this little miracle, I promised her that I would do everything that I could to assure that there would be a healthy environment to support her life and generations to come. And I have tried to keep that promise. Over 20 years, primarily working for environmental justice with the Maine Council of Churches, I've developed and carried out educational programs, and I've advocated for public policy on a broad range of issues, including solar energy and energy efficiency, upgraded fresh water quality standards, and dam removal to open historic runs for alewives on the St. Croix River. Over these years, I have learned that laws, rules, and regulations come and go as new legislatures and governors take office. I've watched my efforts overturned and then reintroduced a few years later. Frankly, it has felt a bit like the Greek story of Sisyphus, who rolled a boulder up a hill only for it to roll back down. The process continued into eternity. As a result of my experiences, I've come to believe we need a paradigm shift in our thinking about how we equitably protect our air, water, and ecosystems for today and into a future we won't know, something foundational we can stand on. Wrongfully, I assumed we had guaranteed rights to these basic ingredients for life, air, water, and healthy ecosystems. Having learned in the last year how environmental rights amendments have been working successfully in the 2 states that have them, Pennsylvania and Montana, I am eager for Maine to follow suit. As we rebuild from COVID's devastating consequences to our health and economy and face certain impacts from accelerating climate change, this constitutional amendment would provide a guiding light for our elected leaders like you to turn to as you steward Maine's resources for a resilient future for all people in Maine. By working for and strongly supporting this amendment, I feel I am taking a big step in fulfilling my promise to Kelsey, now a college junior. For all people in Maine and those yet to come, I ask you to make history and vote ought to pass on LD 489. Thank you.
Thank you so much, Ms. Burt. Representative Dodera.
Thank you, Ms. Burt, for coming today, and thank you for your testimony. I was just curious, in your long career in advocacy, if you could perhaps give us an example of a place where you felt that the Pine Tree Amendment would have been helpful on a front that you were fighting. Thank you.
Sure. I would say certainly the recent case that's come up with the Stone Farm with PFAS. We're learning after the fact. Here's a chemical that has over time, we've begun to realize the kind of impact it's had on drinking water, and we've seen the ruination of a family farm and something that is precious to them. And I feel that it is having something, as has been said by several people, that is really a guiding light, that is principles that we can turn to that we know are embedded in the Constitution. It's interesting because I realized that all of you took an oath of office to uphold the Constitution, and you are every day making environmental public policy, and yet in a certain sense you're not there's no real obligation. I feel like there's a disconnect there. And for me, in a certain sense, this then puts into place something which so many people have talked about, that puts our values, it puts it in a place that we turn to all the time as a reference point. So That would be an example that I can think of off the top of my head. I'd be happy to think of other and, provide ideas to the committee.
Thank you so much. Any additional questions? All right, not seeing any. At this time, I think what we're going to do is hear from some folks that have a differing view. So we're going to ask those that are in the attendee space, if you're here to speak in opposition of the bill, to raise your hand so that we can call on you. Are there any folks in the attendee space here to speak in opposition? Okay, Mr. Sawyer, Mr. Ferdinand, and Mr. Goldberg. We'll go in that order. Welcome, Mr. Sawyer. Are you with us?
I am, thank you. Senator Brenner, Representative Tucker, members of the Environment and Natural Resources Committee, thank you for the opportunity to speak today. My name is Brad Sawyer. I am the Director of Government Affairs for the Maine Rural Water Association. I'd like to start with something that isn't in my written testimony. I'm a lifelong resident of Augusta, and the members of the water and wastewater community are environmental professionals that very much care about the environment here in the state of Maine and have dedicated their lives to ensuring clean drinking water and clean environment. LD 489 is along those same lines, and our members support the idea of clean water, in incredible amounts. Our issue that I'm presenting today is purely one that we feel this bill creates unanswered questions and unforeseen consequences in this space. Water is a unique compound. It's often referred to as the universal solvent. I'll skip over some of the science stuff that I luckily had a colleague help me with, but essentially it's impossible for water to be pure when it's out there. It absorbs so easily that to state that pure water is the standard is really concerning to our members because of the impossibility that they can't deliver that to their customers. Oddly enough, eliminating all impurities from water is actually unhealthy. We need trace materials of certain minerals that we get through water. For example, manganese, while dangerous at high levels, a small amount is necessary for functioning of your immune system, bones, and other things that our bodies do for us every day. In Maine, it's frequently found with iron, and in our groundwater, we often complain about discoloration, other things of that matter. But the fact is we need some of that in our body. The bill also talks about the state being a trustee, which Professor Moffa, I hope I got that right, spoke to the fiduciary responsibility later on. Thank you, Representative. The question, if the state is responsible for this, what happens when some of our incredibly small districts, what happens if there are no longer people to take care of that? Is the state then responsible for that district? Does this prompt districts to kind of pack up and walk away and leave it to the state? I think there are wide-ranging impacts that this bill could have that need to be thought about and discussed. I know I'm running out of time, so I'm happy to answer any questions. And thank you for your time today.
Thank you, Mr. Sawyer. Representative Bloom has a question.
Thank you, Madam Chair. Mr. Sawyer, if I kind of share your concern about the pure water aspect. I think that it's been described going, prior to this, that it's sort of in line with with the other inalienable rights that we're trying to house it in, that would be the appropriate way. But do you have another suggestion? Instead of pure water, what other nomenclature would you use?
Thank you, Representative Bloom. I don't know at this point. I'm not an attorney. I listened to the first hour and a half of this, really wishing I had gone back to school. I don't know what that right term might be. I know in this state we have a proud tradition of local control regarding water, and there are obviously very specific examples of when that doesn't work. But there are backstops in state law to provide for or to deal with those examples. But by and large, local control over water resources has been successful for over a century in our state, and our members that deal with that every day would certainly like to see that continue.
Thank you.
Representative Dudera.
Thank you, Senator Brenner. And thank you, Mr. Sawyer, for your testimony. In my other job, I am dealing often with people having radon water tests, arsenic water tests, uranium. So I must say I thought about that also. And I wonder, I know that, you don't feel qualified to kind of speak on other alternatives, but perhaps in your association, there's someone who could help us with the work session to figure out how perhaps other states have addressed this issue, because there are naturally occurring minerals in water that are good for us, but there are other naturally occurring things in water that are not. So thank you.
Thank you. We're certainly happy to be available for the work session, and I will put that out. I think the first thing that came to mind is obviously the word clean. We discuss clean water a lot. I know certainly in this committee. There are, yeah, I'll leave it at that, I suppose. Thank you.
Any additional questions? All right, thank you so much.
Thank you.
I can't remember what our order was. I believe it was Mr. Goldberg next and then Mr. Ferdinand.
I'm ready to speak, but they're not starting my video.
All right, let's start your video. Let me see if I can help you with that. There we go. Try that, Mr. Ferdinand.
There we go.
Welcome.
Hello, everyone.
Thanks for joining us.
Hi, I'm Bill Ferdinand. I'm a lawyer with Eaton Peabody. I'm speaking today on behalf of the Maine Forest Products Council, which has submitted written testimony. And in listening to the testimony so far, I think we have the same questions that are coming up. And I'm hearing that this is an amendment that's supposed to fill gaps that the legislature has not addressed, or that a local authority wants to address that the state government either hasn't addressed or is preempting the local decision. But I think you have to ask yourself, as Representative Tucker said, who's going to fix that problem? How is that gap going to be fixed? And the way constitutional amendments work is what people go to court and they say, I don't think that this is fulfilling, the legislature is fulfilling its obligation as trustee, or it's not, this environment is not clean enough. I want you to make it cleaner, or I want you to control the resource as a court. And the court will tell the legislature or somebody to do something, either to stop doing something or that they can do something. And the question is, in balancing those values that we have, do we want courts to do that? Because that's where this ends up. The legislature has powers to balance all the things that you guys have been talking about. I don't think there's an issue under the sun that isn't brought to you in one way, form, or another that you guys get a chance to address. And people have open opportunities to do that. We have a very open legislature. And so I'm concerned about the double-edged sword of this, because people talk about protecting farmers and foresters, us too, and we like protection too. but everybody has a different opinion about how clean is clean, how I should be protected from that other activity. We have a right to farm law that protects people from farmers because of the odors and the other impacts that farms have on their neighbors. How much should the trustees protect resources for future generations? How do we sort that out? What is sustainable? What is clean? What would we do with PFAS? I mean, we said, well, we could have addressed PFAS. Okay, what would you have done? You would have gone to court and asked a court to order something to some level of cleanliness. What's the level of cleanliness that we should pick? You guys are dealing with that right now. So my point is that there's a lot to talk about here, and I'm wondering whether this amendment really advances what we already do. And the legislature has a lot of power. Other states, I put in the testimony, you'll see other states' constitutions. Some of them have the legislature written into the amendment to solve that problem. It says, we want a healthy environment, we want a clean environment as determined by the legislature. So it keeps the legislature in the loop. It doesn't shift the power over to a court to try to do something that someone doesn't like or wants the state government to do that isn't being done. And that shift of power is important. You have to look at it. And I put a whole bunch of questions in the testimony that you guys can talk about, and they're coming up in the testimony. This is a big topic, and I think you need to look at it very carefully before you go forward. Thanks.
Thank you, Mr. Ferdinand. Representative Bloom.
Thank you, Mr. Ferdinand. First of all, I don't see written testimony from you.
It's Patrick Strouk.
Patrick Strouk. Okay.
Yeah.
And what state were you referring to when you said that state put the legislature in it?
I'll have to look at, I pulled them. I think Hawaii has one. Rhode Island has another. There's a handful of states that have something like this. It's just that Montana and Pennsylvania have a certain version of this amendment. And you can see New York's in the middle of talking about it too. Massachusetts even has a version of this. So, but what it usually comes down to is making sure that the legislature does its job to balance all these things and to try to provide. I mean, remember that the Bill of Rights has things that the government can't do to people. You can't abridge your right of religion or your right of free speech or your right to gather. This one says it basically says the legislature has to do something. You have to keep a clean environment, or you have to manage these resources for future generations. It's putting an affirmative duty on the government to do things, as opposed to a restriction on the government to keep you from doing something to people. You understand the difference? Mm-hmm. Yeah. So.
Thank you.
Dan mentioned in the chat that the testimony for Mr. Ferdinand, the written testimony, came in under the name Roberta Scruggs. So if you're looking in the committee's paperwork, you'll find it under Ms. Scruggs' name. Any additional questions for Mr. Ferdinand? All right, thanks so much for joining us. Mr. Goldberg is next.
Able to start my video.
Yep, there we go. See if that works.
Great.
Oh, welcome.
Thank you. Hello, Senator Brenner, Representative Tucker, and members of the committee. My name is Neil Goldberg, and I am providing testimony in opposition of LD 489 on behalf of MMA's Legislative Policy Committee. This bill, if enacted, would effectively inundate municipalities with responsibilities that is going to effectively impede their development and likely bring costly litigation. As proposed, the bill is too vague, and that enables anyone to decree their right to a healthy environment has been infringed upon. It broadens the scope of environmental impact to such a degree that practically any development or planning decision could be called into question for its impact to the quoted scenic and healthful qualities of the environment. Because of the amendment's vagueness, municipalities would be held to impossible standards. Development in Maine's communities occurs best and most equitably when statute clearly defines what is permitted and what is not. LD 49 blurs those lines to the extent that past and future development could be called into question. The bill would also open municipalities to claims of negligence and malfeasance from all parties. Interest groups, businesses, and citizens would be able to easily initiate litigation against the municipality based off broad interpretations of this bill. The litigation that occurs as a result is currently unknown, but given the breadth of the rights established under the bill, local expenditures would increase significantly as litigation could drag on for years. Businesses could also be at the same risk, as they may realistically be party to a suit, either as a plaintiff or a defendant. Finally, municipal officials are curious as to why the state would abdicate its authority over Maine's environment. This bill might strip the state of some of the tools it uses to enforce environmental law, and also simultaneously leave it vulnerable to the same challenges in court that municipalities and businesses fear. If LD 489 is approved, municipalities will be engulfed in planning decisions with too many unknowns and costly litigation that could either drain local funds or encourage them to just roll over to deeper pockets. Future planning decisions could be determined by who wins in court, not by local jurisdictions. For these reasons, municipalities and municipal officials oppose this bill. Thank you for your time, and I'd be happy to answer any questions that you may have.
Thank you, Mr. Goldberg. Senator Carney has a question.
Thank you, Madam Chair. Thank you, Mr. Goldberg. Something you said toward the end of your remarks just jumped out at me. You said that this proposed amendment could actually strip the state of its authority to protect natural resources. Can you just give us an example of how that would happen? Thank you.
Absolutely. I mean, so right now, the state is able to essentially create statute and law directing how municipalities and other jurisdictions are going to engage with environmental protection. This would put all jurisdictions at equal footing, which might be a good thing, but ultimately the state might find itself wrapped up in court struggles, just like a local planning board or against another state, for those reasons.
Thank you.
Representative Bloom.
Thank you, Madam Chair. Mr. Goldberg, you represent Maine Municipal Association. So I'm assuming you're familiar with Title 30A of the statutes that talk about the state goals that towns must follow in order they're doing their planning and land use. Are you
not intimately, but yes, aware of it.
Well, it does list, as I was saying earlier, it lists things that it says to protect the state's marine resources, to protect the state's other critical natural resources, including without limitation, wetlands, wildlife and fisheries habitat, sand dunes, shoreland, scenic vistas, and other unique natural areas. There's a whole bunch of things that are sort of guidance, but that's in statute. So it seems like this amendment would be like just really reiterating what we have throughout all of our statutes. This is just one example that lists resources to protect, and that's one of our goals. It's in our best interest, for the state's best interest. So I see it as a just, and I think the best way it described was a backstop. But you're thinking that even though it's in statute to do these particular things, that having this Constitution amendment would be going too far, because it really is reflecting what we already have in statute, is my point, I guess.
Sure, and to the first half, municipalities and local jurisdictions are already doing a lot to protect the environment, and in many regards, it is sufficient. More could be done to bolster what municipalities are doing, especially in regard to climate change initiatives. But this bill, as proposed, might open Pandora's box. And all of a sudden, that list that you read isn't finite, but infinite. And where does that end, I guess, is the question.
Thank you.
I have a question for you, Mr. Goldberg. My inbox is flooded with constituent emails from constituents in my municipality who are concerned about this bill and want me to support it. And they feel like the municipality isn't doing enough, nor is the state. What would I tell them?
We would like to do more under what is currently established. And for many reasons, municipalities have their hands tied. There are permitting processes that they're already jumping through and approval they need. There's funding that they're lacking. There's technical capacity that they're lacking. And the same might go for the state as well. And so is this amendment the way to solve those issues? Probably not.
All right. Any additional questions for Mr. Goldberg? Representative Tucker.
Hello, Mr. Goldberg.
Hello.
My question has to do with the difference between infringing upon rights by action or inaction. Do you see a distinguishing, do you see that you can distinguish between action and inaction? And does that make a difference?
I don't know if I'm the best one to draw that distinction. I believe one does exist, but what we're talking about would ultimately wind up in our court system, we believe, and that's where it would be determined, unless we could somehow resolve that before that happens. I'm sorry not to be able to address that more directly.
That's okay. Thank you very much.
Any other questions for Mr. Goldberg? All right, thank you so much.
Thank you.
So we are going to move back to those that are here to speak for the bill. And we're going to start up again with Ms. Gregor, Carol Gregor. And after Ms. Gregor will be Doretta Colburn and then Eric Best. Welcome, Ms. Gregor. Ms. Gregor, if you could unmute and join us.
Can you hear me?
Yeah, welcome.
Good morning.
I think you might need to turn off one of your devices because you're getting some feedback. Okay.
I'll move from this one. Let's see, start my video. The video, where am I? I gotta turn one of these off.
That's it. You're perfect. We can hear you and see you.
Yeah, we're on, but I have to turn one of these off for sound. Can you hear me?
Yep, you're perfect now. Thank you so much.
You can't hear me.
We can hear you.
Live.
Maybe she can't hear us.
Sorry about this. I've got a sound problem here.
Hit the mute versus unmute.
No, we can hear you.
Okay.
I'm on, but I'm not.
Yes, I can hear you.
You can't hear me, right?
We can. Good. You're good.
You can?
Mm-hmm.
Okay, I'm going to talk. I can't hear you, so I'm going to start. Thank you very much. Good morning. My name is Carol Gregor, and thank you for this opportunity to speak to you all and for all the work you're doing for all of us. I live in Brooksville, the site of the Callahan Mine, which is an ongoing national disaster. I'm an organic farmer. My experience is in building science and design and construction. I'm a system dynamic writer and filmmaker and a student of international science behind our environment as an interconnected and interdependent system of life. I support the Pine Tree Amendment that addresses our ethical stewardship for our environment. Recently, I have written to Sandy Matheson, the executive director of the Maine Retirement System, about my concerns specifically related to the state investment position regarding water and Nestle. After receiving a response from Sandy, I was compelled to speak today regarding the ethical underpinnings of our approach to the rich natural resources Maine has and the business approach now used in our state and specifically pension funds and businesses. In response, the letter from Sandy states, we cannot invest pension funds or divest specific stocks, such as Nestle, using social or environmental principles as an exclusive investment decision factor. This is because pension assets are held in trust funds, and as trustees, we have a legal responsibility to manage the investments for the sole benefit of funding retirements. This means we cannot make investment decisions based solely on environmental principles or preferences, such as the one you are requesting, Sandy. Let me repeat what she said. The sole benefit of funding retirements do not necessarily include social or environmental principles. And I must ask, at what cost? When did our economics forget our need to protect our environment for life itself? The system of life is connected in the world. All of nature is giving nature is dependent and is never separated. It's an interdependent system of which we are part, of which life is born. The life-giving nature of water, once disturbed, leaves life and land and life barren, as seen throughout the world. The scientists in the Army Corps have done more damage than is possible to imagine, disturbing organically attached ecosystems and that are dependent on the survival of each other, including us. The extraction of water is catastrophic to the survival of life. Dr. Paul Farmer, speaking about Haiti's water management by the Army Corps, everything you touch matters, as entire communities were destroyed by the short-sighted vision of nature, poverty, and extinction of natural biosystems were destroyed. Fritjof Capra and Pope Francis explain, even as the quality of available water is constantly diminishing, in some places there is a growing tendency, despite its scarcity, to privatize this resource, turning it into a commodity subject to the laws of the market. Yet, access to safe, drinkable water is a basic universal human right, since it is essential to human survival. I'll just repeat that. It is essential to human survival. As such, is a condition for the exercise of other human rights. It is time to give natural resources the same rights awarded corporations, and this is also for them to have human rights. No business or individual ethically has the right to profit from damaging any part of the natural system.
Ms. Greger, your time is up.
Systems, it is time for Maine to not allow natural resources that are irreplaceable to be sold off to the benefit of a few. It is time to stop destroying our earth and to make businesses a part of a healthy solution and life-sustaining possibilities. Leadership to manage climate change should suggest investment use of our lands and winds, oceans, and farms for the strategic solution to prepare for the future. Taking our water out of its natural order shifts the environment and is not based, just 2 seconds, on good science or good solutions. Thank you. Thank you for your time.
Thank you, Ms. Greger. Unfortunately, I'm not sure how we're going to be able to ask Ms. Greger questions because she can't hear us. Yep.
Oh, I think it was all over here. Hey, Dick, can you come here? Because I can't answer any questions if anybody has any.
Does anyone have a
I'm
question
I'm
for
muted.
Ms. Greger? I'm not seeing any. So for now, I think we'll move on to Ms. Colburn. Thank you so
We
much,
have the
Ms.
other
Greger.
one off. We tried the other one else. We can turn this sound bar on. It's light, but I can hear it at least.
This is our exercise in humility here. Patience and humility. All right, welcome, Ms. Colburn.
Oh, thank you. Thank you.
Thank you for joining us.
Thank you for having me, Senator Brenner, Representative Tucker, and distinguished members of the committee. My name is Doretta Colburn, and I'm from Waterford. I speak today on behalf of the Maine Council of Churches, also as an ordained pastor of 26 years, an organic farmer, and a proud grandparent. In each of these roles, I honor the value of every person, and I work hard to give my best to them, whether it is physical, spiritual, and/or emotional nourishment and support. Along with that, I cannot imagine anything other than the rights for every person to clean air, pure water, and a healthy environment. That's why I come here today to urge you to vote ought to pass on LD 489. As a farmer and a grandparent, let me tell you about my two grandsons who come to our farm regularly. They are 3 and 6 years old and the most enthusiastic harvesters. Not that much goes into the basket as they go from the mulberry tree to the raspberry patch to the fresh produce in the gardens. As they eagerly reach for fresh samples, they take for granted the healthy environment, clean air and water that we are so fortunate to be surrounded by. Our grandsons don't question it. Why should they? To them, how could it be anything else but a natural expectation that the air they breathe is pure, the water they drink and play in at the lake is clean, and the environment that they hike in and enjoy every day is nothing but healthy? They should not have to question it, nor should anyone else. So I have become an advocate for our grandchildren, but not just for them. I am speaking up for the rights of everyone to clean air, pure water, and a healthy environment, without which all life and we suffer. My faith informs me of a responsibility to care for this remarkable planet that we are a part of and do what is just and right for the benefit of all. Yet even as we seek these rights for all people, it is imperative that we recognize the right that is Earth's to these basic needs to sustain and flourish it. The pure joy and sense of freedom my grandsons feel, trusting in the environment around them, is something they and everyone else should always be able to count on. The Pine Tree Amendment will help to protect those rights. So I urge you again, vote ought to pass on LD 489. Thank you so much for considering my testimony.
Thank you, Ms. Colburn. Are there any questions? All right, not seeing any. Next up will be Eric Best, and then Heidi Vertheller, and then Jessica Cooper. And Mr. Best, I can help you with your video.
Okay.
There we go. Welcome.
Thank you very much. Hi, I'm Eric Best, and I appreciate the opportunity to speak to the committee briefly, just to raise my voice in favor. I began my career many years ago as a reporter, and then I learned something called scenario thinking or scenario planning, which I've done for 30 years around the world. And in recent years and now months, I appreciate that between climate change and COVID, many people are more aware that what we've done to get us here isn't enough going forward. So taking some notes from other witnesses this morning, I just want to underscore 2 points. First, what got us here isn't enough. Secondly, that Maine, of all states, passing an amendment to the Constitution to declare the primacy of a healthy environment is a very important signal to send around states, around the country, really around the world, as an affirmation of something that's required for stewardship in the future, for generations counting on those who came before. So that's really the nut of it. From everything I've learned in my life about what matters in the future really needs to be taken care of sooner than later. I think the reason that we're having this conversation right now is that there's a broad recognition that what brought us here won't get us where we need to go, that climate change and COVID are examples of borderless environmental challenges, and we need to put a stake in the ground and declare, if you will, the sacredness of the environment going forward, which in earlier generations, when we lived with the commons and for the commons, was more broadly understood, certainly by the indigenous populations in this country. So that's the net total of my plea here. Send the signal. Somebody said, fortify the right with expressed language, a paradigm shift in our thinking, a guiding light about embedded principles, a strong, clear clarion bell. And I think that's what Maine can provide on this provision, a strong, clear clarion bell. And I urge you to do that. Thank you very, very much for the time to speak to you.
Thank you, Mr. Best. Any questions for Mr. Best? All right, not seeing any. Thank you for joining us, and we'll move on to Ms. Vertheller. And I'm going to turn on your video.
How was that?
Here we go.
Great. Am I there? Oh, there
You
I
are
am.
here. Welcome.
Okay. Thank you so much. I'm opening my my oral testimony here. Good morning, esteemed chairs, Honorable Ralph Tucker and Stacy Brenner, and your fellow Honorable Joint Standing Committee on the Environment and Natural Resource members. Thank you for your hearing today. I am Heidi Johanna Viertaler, a social and environmental advocate from Southern Maine in Wabanaki Territory near Brunswick. I urge you to pass the Pine Tree Amendment, the PTA LD 489, for the sake of the future of our great state of Maine. I have devoted my life to making the world a better place by the most effective means necessary, especially saving the ecosystems that I care about from my homes across the country, especially here in my decades-long home in Maine. I have thus seen the need to enshrine this law into the amendment. The PTA will make clear that government's duty as trustee is to protect the state's natural resources for the benefit of all people, including future generations. In fact, I wish that we could be considering a similar amendment to our national constitution. From my 4 decades of advocacy work, we need this PTA because I know that the laws that can be made and unmade, but the Constitution is permanent. It would be a guiding North Star for all in our state by providing guidance that ensures government decision-making and considers the environmental impact, such as the costs of environmental harm, including illness, cleanup costs, flooding, drought, and declining property values early in the process when prevention of such pollution, environmental harm is most possible, and by ensuring that government laws, regulations, decisions, permits, and actions avoid such degradation rather than responding to it after the fact, thus strengthening healthy economic growth. This would thus preserve Maine's ecosystem as the truly beautiful way that life should be. Please see my submitted written testimony for ways that I have been blessed with the inspiration of our natural world, especially here in Maine, and my advocacy for my enthusiasm to see this PTA passed into our Maine Constitution. Please support the Pine Tree Amendment. This will not only position our state to have the best possible thriving future, but enable our state to serve as an example of good state stewardship of our natural world, to inspire not just other states in our nation, but countries around the world to also enshrine the protection of our ecosystems for all people into our constitutions.
Ms. Vertheller,
Thank you for your consideration. I would be grateful for the opportunity to answer any questions and be of further assistance to you, perhaps on the work session.
Thank you so much. Are there any questions? All right, I'm not seeing any. Thank you for joining us this morning. And next up is Jessica Cooper. Following Ms. Cooper will be Lori McDonald and then Mark Brown. Welcome, Ms. Cooper.
Yeah. Good afternoon now, Senator Brenner, Representative Tucker, members of the Environment and Natural Resources Committee, and my gratitude to Senator Bennett in my district for corresponding with me and co-sponsoring LD 489. Thank you all for the opportunity to speak today. My name is Jess Cooper. I am 25 years old. I'm from Norway, Maine, and I'm here urging you to vote ought to pass on LD 489. I am a young mother, a 7th generation farmer here in Maine, and a youth climate action coordinator in Western Maine. I enjoy working with youth all over the state, acting as a bridge between young people and adults to share and amplify what young people are experiencing here. The person that I'm inspired to advocate for most is my daughter. In 2015, my daughter Adelaide was born with a rare genetic disorder called Prader-Willi syndrome. People born with this genetic disorder have the same core symptoms: low muscle tone, inability to feed at birth, and then as they grow, it changes to include hyperphagia, a phenomenon where the brain causes them to experience insatiable hunger at all times. The health issues that come with this diagnosis can be numerous, one of the most prominent being obesity, caused by the uncontrollable hunger and low muscle tone, making it more difficult to do strenuous activities for even short amounts of time. Getting my daughter outside every day is critical for her well-being, as well as having access to pure water, healthy local foods, and safe, thriving outdoor spaces to explore and exercise in. We see well over 10 specialty doctors regularly, and the one thing they all echo is to get my daughter outside, playing and moving as much as possible. Our favorite place to go is one of the oldest white pine groves in the state, a hidden gem here in Norway, Ordway Grove. And I've watched as she's transformed day after day, her mood, her strength, her ability, her sense of wonder and place. 10 years from now, she'll be 15 and will be old enough to advocate for a safe and livable future. Until then, my voice is her voice, and I have the opportunity to make an impact on her future now by working to establish her undeniable right to a healthy environment. No law, permit, or corporation should be able to jeopardize those rights, and it scares me that currently they can. It is up to us to protect our environment, to ensure that our beautiful state is clean and safe, to advocate for the health of our friends, family, and neighbors. Everyone deserves the right to clean air, clean water, and a healthy environment around them. And my daughter's direct need for those things is what drives me to advocate for this amendment to Maine's Constitution. In Maine, some of the first places we have an opportunity to find wonder, learn about ourselves, breathe deeply, and begin to build healthy lives is outside. Maybe under an old maple or pine tree, in a leaf pile on a trail or a mountain, beside a lake or the ocean, under our very first snowflakes or a perfect bluebird sky. I'm here to ask each of you to think back to your first moments of wonder outside, to consider that you and your child too should have a right to that healthy environment, and to support LD 489 and see our Constitution amended to guarantee these rights. Thank you again for having me here. I'd be happy to answer any questions.
Thank you so much, Ms. Cooper. Are there any questions? All right, thank you for joining us. I don't see Lori McDonald next, so we'll move on to Mark Brown. Welcome, Mr. Brown.
Hello, and good afternoon, Senator Berner and Representative Tucker, and members of the Committee on Environment and Natural Resources. Thank you for the opportunity to provide testimony on LD 489. I speak of support for this amendment on behalf of 350 Maine and 350 Down East. I was introduced to Maine 40 years ago as a forestry student at the University of Maine in Orono. I fell in love with the state, particularly the natural environment. I am now retired and live in Maine in beautiful Washington County, where I now enjoy the bold coast, the forests, rivers, lakes. Clean air, clean water, and healthy environment is essential to everything that is Maine. As to the importance of a constitutional amendment, laws and regulations do exist to protect our environment, but these are only good to the extent to which they are enforced. Often these laws are used to pollute legally by granting waivers and permits. It takes a constitutional amendment to guarantee the protection of our environment. The Maine government legally would become trustee of our natural resources, with all people in Maine being their beneficiaries. The rights of Maine citizens to clean air, clean water, and a healthy environment will be applied to all of us and all future generations, regardless of ethnicity, age, gender, or faith. I would also like to speak briefly to the importance of passing the Pine Tree Amendment to the economy of Maine. Commercial fishing, forestry, tourism, recreation, all rely on a healthy environment. Without a constitutionally protected environment, each of these industries would be threatened. Without these economic drivers, Maine would be in dire straits financially. We are also paying for not having an amendment protecting our air, water, and environment. We are paying for increased health costs due to respiratory issues, cancers, and premature deaths due to environmental toxins. So in conclusion, I'd like to quote Franklin Curry. He was a Pennsylvania representative in 1970 who proposed a Green Amendment in that state. Quote, population and technology have run amok through our environment and natural resources. If we are to save our natural environment, we must therefore give it the same constitutional protection that we give to our political environment. Thank you for your time.
Thank you, Mr. Brown. Any questions for Mr. Brown? All right, not seeing any. Thank you for your testimony. And next up we have Mark Rains, Michelle Henkin, and Noah Luna. For the committee and those attending at 12:30, we'll plan on taking a break for a half an hour. We do have quite a few folks left to testify. Okay, Mr. Rains, welcome. Mr. Rains, you're on mute and we can't see you, so you can unmute and turn your video. There you are, welcome.
Thank you, Senator Brenner and Representative Tucker and committee members. I've lived in Vienna for the past 22 years and before that 6 years in Caribou. I submitted 6 points as written testimony. A theme throughout them involves how in the US Constitution, the Bill of Rights was designed to protect us from the practices of European governments at the time. Subsequent amendments provide protection within the US government. The proposed amendment could judicially protect the rights of citizens from the ways that multinational corporations can overwhelmingly influence, finance, and lobby governmental legislation and executive policy. As a psychologist, I would add that a Harvard study predicts that within the century, carbon dioxide levels could increase to a point that cognitive functioning needed to respond to crises could decrease by 20%. Maine has an opportunity to lead in the process before it's too late. On behalf of the next 7 generations, I urge you to pass this forward to the legislature and Maine voters. Thank you.
Thank you, Mr. Rains. Are there any questions? Not seeing any. We thank you for your time this morning and your testimony. And welcome, Ms. Henkin.
Senator Brenner, Representative Tucker, and distinguished members of the committee, greetings. My name is Michelle Henkin, and I live in New Harbor on the Pemaquid Peninsula. I am here to testify in support of LD 489, amending the Constitution to enshrine the right to clean air, pure water, and a healthy environment for all people in Maine, including future generations. I love the state of Maine, and I have carried a question with me for a long time. How can I give back in a meaningful way to this place that means so much to me? I came across a book by Maya van Rossum called The Green Amendment, in which she describes the power of environmental rights amendments to provide foundational protections for the places we hold dear. I learned that unless these rights are explicitly protected in our Declaration of Rights, that we don't have a clear and unambiguous constitutional right to clean air, pure water, or a healthy environment. I had always assumed I had those rights. Who among us doesn't feel that we have a right to breathe clean air and drink and bathe in clean water? I had always taken it as a given. Still disbelieving, I read through the Maine state constitution and there was no mention anywhere of the environment or of air or water. Then I read the debates and journals of the Constitutional Convention of 1819, a record of all the discussions the framers had as they drew up Maine's constitution. There's not a single conversation there about the land and the waters or the air or the environment. Herb Adams, a former legislator from Portland, in a piece he did for the Maine Bicentennial, explained that the framers of Maine's constitution were far-sighted in ending Article 1 with Section 24, other rights not impaired, which they used to assure that their document would serve into a future that they could not yet imagine. In the Maine of 1819, there were abundant natural resources, endless forests and free-flowing rivers, plenty of fish and game. The framers would have had no reason to imagine that essential human rights, rights to clean air, pure water, and a healthy environment could possibly be threatened. But they gave us Section 24 because they anticipated that there would be the need in the future to assert the people's rights in ways they had not yet foreseen. If the framers of the Maine Constitution were living in today's Maine, where the amount of wild-caught fish you can safely eat in a week is prescribed, where landfills are accepting trash from out of state, where people living next to oil tanks can't open the windows of their homes, they would surely recognize the need to protect the air we breathe and the water we drink. Without clean air and clean water, without a healthy environment, how can we fulfill the promise of that very first right to enjoy and defend our life and liberty, and to pursue and obtain safety and happiness? I urge you to vote ought to pass on LD 489. Thank you, and I'm ready to take any questions.
Thank you, Ms. Henkin. Are there any questions? All right. Thank you for joining us this morning. And Noah Luna is next. Welcome, Noah Luna.
Hi, can you hear me?
We can. Welcome.
My video doesn't see. Oh, here we go. Okay.
Oh, there we go.
Senator Brenner, Representative Tucker, and members of the committee, greetings. My name is Noah Bader, and I'm here to testify in support of amending the Maine Constitution to guarantee the right to a healthy environment. I am living the existential experience of youth at this moment. It is so easy to feel hopeless. I have quite a few friends who have no hope for the future, and even I feel tempted to walk through life lacking hope. Like a well run dry, all positivity and optimism evaporated with the last drop of water. Life without hope is not a life worth living. We need hope and optimism, faith in ourselves, each other, and in our future. Otherwise, the point of living is lost. I want to know that the state of Maine recognizes my right to clean air, pure water, and a healthy environment. Without these, I have no hope or trust in my future. Action or inaction are choices we make. Each action has the ability to influence and encourage others to stand up to protect our air and water, and has an equal opportunity to normalize inaction, carelessness, and lack of responsibility and accountability. Will we give up out of hopelessness? Or will we persevere and try our utmost to fight for the protection of the environment? I refuse to give in to hopelessness. As a youth who cares deeply about the environment and equitable rights for all people, I feel a deep sense of responsibility to try my hardest to advance the ideals I declare as important. In Maine, a large portion of our identity is built upon our deep care for the outdoors, forests, waterways, and ocean, and all Mainers deserve a right to enjoy the beauty of Maine's outdoors for generations to come. I intend to fight for the adoption of the Pine Tree Amendment so that my future children and grandchildren are sure to be able to experience and benefit from nature just as I and those before me have done. I want the state of Maine to commit to the preservation and protection of the environment we rely on. This shared hope and faith is what will bring us together, and it will be the binding agreement encouraging us to fully commit ourselves and become true stewards of the earth together. I believe the Pine Tree Amendment is a way to ensure our rights to a clean and healthy environment into the future. The upcoming generation has the opportunity to take full initiative and make environmental justice and climate policy our top priority and the Pine Tree Amendment would enable us to do so. If you adopt this legislation, you are giving us the hope we need. You have the opportunity and power to enact this amendment. You hold that responsibility to younger generations to grant us our right to a future. So I ask you to vote ought to pass on LD 489. Thank you.
Thank you so much for joining us this morning. Are there any questions for Noah Luna? I'm not seeing any. Thank you for your testimony. Next up is Peter Garrett. Or Phoebe McDonald. I don't see Mr. Garrett in the attendee space. Welcome, Phoebe. Phoebe, you'll want to unmute yourself. Welcome. Sarah Berg?
There we go. I'm sorry, we didn't hear what you said.
Welcome. You're welcome to start any moment.
Okay. Go, Phoebe.
Senator Maxman, Senator Bennett, honored representatives, thank you for this opportunity to offer my testimony. I'm Phoebe MacDonald, 11 years old, and I attend Ocean Avenue Elementary in Portland, Maine. I've been working for clean oceans and rivers since I was 7 years old. I helped the city of Portland ban plastic straws to keep them out of the ocean, and I was part of the Children's Trust to get Maine to enforce carbon emission standards. A polluted environment is more dangerous to plants, animals, water, and people than a loaded gun. It seems weird that Maine Constitution guarantees my right to own a gun when I'm an adult, but the Constitution does not protect the air, water, and land from destruction and pollution. That's crazy. And the environment needs protection now more than ever before because of climate change and industrial pollution and all kinds of other big threats. I'm angry that I'm spending my life fighting for rights that should already be mine, like clean water. I want our beautiful Maine beaches to still exist when I grow up, and at the rate of carbon emissions right now, they will be gone underwater when I'm the age you are now. Step it up, grown-ups. We need to seriously deal with major problems by getting this amendment passed. Thank you.
Phoebe, I appreciate your testimony. Thank you for joining us this afternoon. And I have one question for you.
Yes.
Have there been other issues that have moved you as much as the environment?
I'm not really sure. Well, women's rights is one of them, because that's a big issue these days. But the environment has been something that I've been working for a while. So that's like the one standing issue that I'm always thinking about.
Thanks for sharing your testimony. Representative Gramlich has a question for you.
Thank you, Senator. Phoebe, thank you so much for coming and having the voice of youth be heard in front of our committee. I wanted to let you know, given that you are interested in women's issues, that today is International Day of the Woman. And my question for you is, and I hope it's yes, and I think it might be, do you intend to continue having this wonderful, strong voice that you have on issues that you care about moving forward.
Definitely.
Well, thank you very much and keep up the great work.
Thanks.
Any additional questions? All right. So let's go ahead and take a break now. We'll meet up again at 1. And for those of you still waiting in the attendee space to offer your public testimony for the public hearing, we will get to after our short break. And I think with some lunch in us, we'll be quite a bit more excited to continue along once we're nourished. All right, thank you all so much, and make sure you put yourself on mute and turn your screen off, or you can click out of the Zoom and join us again at 1 o'clock. Thank you. right, how's everybody? All right, welcome back for the rest of our public hearing on LD 489. We are still the Joint Standing Committee on the Environment and Natural Resources. And we have still some more testimony to hear. Next up will be Reverend Richard Kilmer, and then Richard Nelson, and then Roberta Hill. Welcome, Reverend Kilmer. Mr. Nelson,
Good afternoon.
Turn your camera off.
Yeah, it was off.
No, let's see, Mr. Kilmer, I'm going to turn you on, and Mr. Nelson, I'm going to turn you off until we're. There we go. Perfect. Welcome.
Good afternoon. Thanks for hearing me. I'm Reverend Richard Kilmer, representing Defend Our Health. It was formerly called the Environmental Health Strategy Center. I speak in favor of LD 489, which is proposing an amendment to the Constitution of Maine to establish a right to a healthy environment. Much of the environmental degradation which exists in this world hurts people. This proposed amendment to the Maine Constitution, the Pine Tree Amendment, PTA we're calling it, would guarantee that people have the right to pure water, clean air, healthy ecosystems, just like they have other rights, including free speech, the right to assembly, to possess firearms, and to worship as they choose. The PTA prohibits the state from infringing on the rights of the people of Maine to have these things, to have these rights, either by action or inaction or through the action of others. Under this amendment, in order to guarantee those rights to all people in the state of Maine would have to conserve and protect and maintain the natural resources of the state so that people are protected from environmental degradation and the harm that it causes both now and for future generations. The PTA ensures that no legislature, governor, law, or permit can take these rights away. Laws can be made and unmade, but the Constitution is permanent. This amendment gives the people more opportunity to challenge the government, including legal suits, when a law, permit, or any other action threatens these basic rights. The PTA will also empower communities to address any government's unconstitutional infringement on environmental rights. Here are some things that will happen if Maine has the Pine Tree Amendment. The PTA could advance drinking water protections from PFAS, which is a major concern of Defend Our Health. It could require consideration of science and impacts before permitting environmentally damaging operations. And it secures cleanup of those toxic contamination. Low-income communities and communities of color are particularly impacted by exposure to the manufacturing of toxic chemicals in or near their communities. PTA could help protect those communities by making it harder for industry to build new manufacturing plants or to get permits for activities that would harm the environment near those communities. The PTA is about the people of Maine, assuring them of the basic right to a healthy environment. Defend Our Health urges this committee and the legislature to approve the Pine Tree Amendment. Thank you so much.
Thank you so much, Reverend Kilmer. Are there any questions? Not seeing any. I'll thank you for joining us. And our next speaker is Richard Nelson. Welcome, Mr. Nelson.
Senator Brenner, Representative Tucker, and members of the committee. Good afternoon. I'm Richard Nelson, speaking in favor of LD 489. Usually I stand, or as the occasion, sit here as that fisherman from Friendship, speaking of the fisheries or the effects that climate greenhouse gases have on them and the world. But even though the lobster industry serves as a prime example that conservation go hand in hand with economic health, today it matters little if the speaker is a lobsterman, a teacher, or even legislator. The issue at hand is so basic and fundamentally shared between us as humans as the air we suck into our lungs or the water that passes our lips. Each of us is dependent on life-sustaining environment around us on this planet. Today, this unquestionable relationship finds a bit of confusion when stated as a human right. We hear calls for the rights to health care, rights to good paying jobs, part-time paid time off from those jobs, or even rights to basic housing nowadays. As much of these calls are based on good concepts and intentions, some might wonder if people should ever have left the womb. The Pine Tree Amendment has no association with the precepts of all about me, or the have it all now, or the politics of individual needs being met by efforts of others. On the contrary, it's about sharing the resources of this planet with all, and sustaining it for future generations. Not to inhibit economic growth, but to allow for its continued abundance. About recognizing our symbiotic relationship with the environment. Simply, we take care of it, and it takes care of us. I look at this amendment as a missing block in the foundation of Maine's Constitution, one that is needed to set a level with the desires of its people. An ideal not meant as an obstruction on our course, but as a navigational aid for our government and judiciary to maintain it. Thank you. Any questions?
Thank you, Mr. Nelson. Any questions for Mr. Nelson? Thank you for joining us. Next up is Roberta Hill. Welcome, Ms. Hill.
Thank you. Hello, members of the ENR committee. My name is Roberta Hill, and I live in Buckfield. I'm an aquatic ecologist, an educator, an organic grower, an outdoor enthusiast, and a proud grandmother of 4. I'm testifying as a private citizen today in favor of LD 489. I've been working in environmental protection in Maine for the past 30 years. My focus has been primarily on Maine lakes. Over that time, I've worked with literally thousands of people who are passionate about our lakes and working hard to protect them for future generations. But it has become clear to me that all of this incredibly dedicated and important work will largely be for naught if we do not address the climate emergency that is bearing down upon us, that indeed is already here, warming the Gulf of Maine faster than nearly any marine system on the planet, sending new invasive species our way at an alarming rate, changing the timing and tone of our seasons, threatening our lakes, including those that serve as public water supplies, with toxic algae, and disrupting all of the natural cycles that for thousands of years have made Maine the very place that it is. Scientists here in Maine and across the globe tell us in no uncertain terms that when it comes to greenhouse gas emissions, we have 1 decade now to make a complete about face, Slowing down is a start, but it is not enough. It is as if we're driving down a road and suddenly come to a bridge that has collapsed before us. Slowing down is not sufficient. We need to hit the brakes and stop going in that direction and find a new way to get to where we need to go. Our current environmental laws are simply not sufficient to address the urgency of the reality that we now face. These laws, for the most part, however well-meaning, were not even from the start intended to stop pollution. They were intended to regulate it, to slow it down. And many of the laws that were so promising when first enacted have eroded since, primarily by powerful interests working at the federal level, but with serious implications for all states, forces that have steadily managed to gain political power within our system and then bend the system in their favor. In the process, both our environmental laws and the very democratic institutions that helped to first enact them have become weakened at a time when we urgently need them the most. The Pine Tree Amendment, with its equitable consideration for the health and well-being of all Mainers, including future generations, has the ability to help us find our way, to shift our focus, to get us going in our new direction. And in the process of helping us to find our new direction environmentally, the amendment, by giving us, the people of Maine, a fighting chance to help protect our neighborhoods, our communities, our children's health, our cultural heritage, and very way of life, will also be providing us with the new tools with which to begin restoring the vibrancy of our democratic instincts and institutions. I urge you to support this bill and for your service to Maine and for your consideration of my testimony. Thank you.
Thank you so much, Ms. Hill. Are there any questions? Not seeing any, but thank you for joining us.
Let me ask a question.
Whoops, Ms.
All right.
Representative Bloom has a question.
Thank you, Ms. Hill, and thank you. I agree the climate is a very big issue, but I think we are taking some really good steps here in Maine. We started the Climate Council, and I've been on it and worked really hard on it. So I'm encouraged by some of the things that we're doing and making inroads. So I don't see this amendment as starting down a new path or anything. We're on that path. And I want to say that very strongly. I feel that. Do you feel that?
I feel it. I'm working on it too in many ways. And I feel that we are on the path. I believe this amendment will really help to enliven, again, as I said, the democratic processes that are really going to be necessary to get us all rowing in the same direction. And I believe it has the power to focus the mind in that way. As an educator, I believe that it will have just the power to help bring a new awareness to people who may not have quite fully grasped the urgency of our current situation. But I agree, Maine is on the right path. I'd love to see us be a national leader in that regard, and I believe we're on the way to do that. Thank you.
Thank you.
Any additional questions? All right, thank you so much. And next up is Sue Inches.
Hi, good afternoon.
Good afternoon and welcome.
Thank you, great to be here. Senator Brenner and Representative Tucker and members of the committee. My name is Susan Inches and I'm testifying in support of LD 489. I've been an environmental advocate for 25 years, including serving 7 years as Deputy Director of the State Planning Office. And while I was there, I worked on a portfolio of environmental issues. And specifically this afternoon, I want to speak to you about how the proposed amendment to the Constitution is good for Maine's economy. So in 2009, I worked to pass legislation called Quality of Place. This legislation called for our natural resource assets to be the basis of our economy. What it did is it prioritized funding for infrastructure to enhance these assets, things like public water access, trail building, and restoring our historic downtowns. By enhancing these assets, the thinking was, we would attract and grow our business sector. This bill passed with strong bipartisan support, but the next year it was repealed under the LePage administration. So as this example shows, laws, even laws with bipartisan support, are not permanent. LD 489 would establish the right of all Maine citizens to clean air, clean water, and a healthy environment, and would guarantee these rights for present and future generations. And I believe that if you do not pass this bill, the health of our environment, our economy, and our people is up for grabs with each swing of the political pendulum. Going further, LD 489 gives us a way to protect and grow Maine's economy. Maine's identity and economy are based more than ever before on our natural resources. Think about it. Agriculture, forestry, and fishing are our traditional industries, but now we have cruise ships, outdoor recreation of all kinds, hospitality, tourism, and travel. I was reminded of this lately when I visited the North Woods a couple of weeks ago. The Nordic ski lodge where I was staying was full, and snowmobiles filled the general store parking lot down the road. And now, as a result of COVID, we're seeing a surge in new residents, both families and professionals. These people are moving to Maine because of its clean air, clean water, and healthy environment. If LD 489 passes, we would be sending a clear message to the world that the outdoors and a clean and healthy environment is our identity and our priority for the long term. With the Pine Tree Amendment in place, an investment in Maine, whether in real estate or to start a business, becomes a good and safe investment for the long term. If we don't pass LD 489 and a citizen referendum to support it, our competitive advantage, our quality of place, would be eroded by harmful developments over time and eventually lost. So in summary, we need this constitutional amendment to protect ourselves from harmful development and to tell the world we are a safe, clean, and healthy place to invest, to raise a family, to work, or start a business. A vote in support of LD 489 is a vote for Maine's clean economy and for our prosperous future. Thank you so much, and I'm happy to answer any questions.
Thank you so much. Are there any questions for Ms. Inches? Not seeing any. Thanks for joining us.
Great, thanks for having me.
So at this time, if you are in the attendee space and you are here and to speak for the bill, and you have not shared your testimony yet and you would like to share it, if you could please raise your little mechanical hand so I can call on you, that would be great. Okay, so there are 3 more folks to speak in favor of the bill. First is Haley Arno, then Marty Fox, then Heather Spalding. Is it Hallie? Am I saying it right?
Yeah, it is. Thank you so much. Hello to Senator Brenner, Representative Tucker, and the members of the Committee of Natural Resources and Environment. My name is Hallie Arno, and I proudly am coming to you as a representative of Maine Youth for Climate Justice, a coalition of over 300 youth around the state who are fighting for bold climate action and a just transition to a livable future in Maine. I am writing in strong support of LD 489. Breathing clean air and water are the most basic of human needs. These must be human rights reflected in our Constitution. Furthermore, we must look beyond today and guarantee these rights for future generations, and safeguard them by ensuring the health of ecosystems that supports all life on this planet. Protecting ecosystems includes and transcends human needs. It protects plants, animals, and the earth itself. Maine Youth for Climate Justice recognizes the existential threat that climate change poses to our futures and to all future generations. We must both reduce emissions and mitigate the adverse impacts of the climate crisis. Thriving environments are more resilient. For example, healthy estuaries can absorb excess water and nutrients, and diverse ecosystems are less likely to collapse with the loss of a single species. By protecting our land, air, and water, we create more resilient ecosystems and therefore resilient communities. The climate is changing now, so mitigation and adaptation are non-optional. Protecting Maine's environment means protecting our people, history, and economy. Because of our reliance on the environment due to the natural resources and tourism economy, we must be leaders in pushing other states to take aggressive action on climate change and environmental harm. Maine Youth for Climate Justice acknowledges that the climate crisis is rooted in systemic failures and forms of oppression, and disproportionately affects marginalized communities. Many of those who have contributed least to the climate crisis are those who will likely be most affected. LD 489 will ensure that all Mainers have equal access to a healthy environment, regardless of class, race, or background. This is not just an issue of the environment, this is an issue of justice. Many of us were lucky enough to grow up surrounded by Maine's natural beauty, and we hope to pass that on to our children. Now is the time to cement our legacy as environmental stewards into our Constitution. As youth, we will live to see the effects of climate change and environmental degradation, and we must ensure that our children have clean air to breathe, clean water to drink, and functioning ecosystems to rely on. Otherwise, we will feel the effects of a crisis that we did not create. It is critical that we take action now to protect the environment and therefore our futures. Thank you for listening, and I'm happy to take questions.
Representative Dudera has a question.
Thank you, Madam Chair. Hallie, thank you very much for coming today. Did you say that your Maine Youth for Climate Justice has 300 members? Is that what you said? Or how many members do you have? I guess I should ask.
Yeah, currently a little over 300 members.
Great. And has your group has discussed this? Sorry, that's my timer going off. And your group has discussed this amendment to the Constitution and had a robust discussion on it? Just curious.
Yes, we have. We have bi-weekly meetings, and not all 300 people are on every meeting, but we have had a discussion and worked together on testimony. Thank you.
Representative Ziegler.
Not a question, but it's nice to see you again, Haley. I just wanted to say, and congratulations on going over to COA, and Representative Darrow, she graduated from Watershed in your town, but she lives in my district.
Thank you. Great to see you both here.
Are there any other questions for Ms. Arno? Thank you for joining us, and thanks for your patience as we moved through everyone today.
Thank you so much.
And Marty Fox is next. And after Marty Fox will be Heather Spalding. Mr. Fox, you're still muted.
Okay.
Oh, there we go. We can see you in.
Okay, great. I'll make it brief. I'll shorten what I said because everybody else has spoken so eloquently about it. But I just want to make one point. I consider this bill to be bipartisan because it prevents any government's authority to infringe upon our rights to clean air, clean water, and to a clean environment. I don't know about you, but I'd like to see Maine's air, water, and land be preserved for my grandchildren and their children for generations to come. That is why I encourage you to vote ought to pass on this proposal. I'll be glad to answer any questions.
Are there any questions for Mr. Fox? Representative Dudera.
Thank you, Madam Chair. Mr. Fox, I'm just curious, and I apologize, I could look this up on your written testimony, but what town are you from? Did you say that?
Wiscasset. Representative Henry's district, Wiscasset.
Wiscasset. Oh, great. Okay, thank you.
Any other questions? All right, not seeing any. Mr. Fox, thank you for joining us this afternoon.
Thank you.
And hello, Ms. Spalding, welcome.
Good afternoon, Senator Brenner, Representative Tucker, and members of the Joint Standing Committee on Environment and Natural Resources. My name is Heather Spalding, and I'm Deputy Director of the Maine Organic Farmers and Gardeners Association, MOFGA. I've submitted written comments in support of LD 489, and I'll abbreviate my remarks. I just wanted to be on record. This is a big day, and this is a really important piece of legislation. This bill aligns with MOFGA's mission, which advocates for organic agriculture, illuminating its interdependence with a healthy environment, local food production, and thriving communities. We're helping people in Maine and beyond gain access to healthy, locally produced food and an overall reduction of toxic chemicals in our food, air, and water. We've been busy in the legislature this year advocating for programs that rebuild the health of our soils. We're seeking an end to spraying synthetic carcinogenic, neurotoxic, endocrine disrupting agrochemicals on our land. We're seeking justice for poor, rural, underrepresented, and underserved communities that bear the brunt of industrial pollution. And we want to show solidarity for the Wabanaki people who have inhabited the region in harmony with nature for almost 15,000 years. Most of the bills that MOFGA is working on in this legislative session seek solutions to environmental and human health problems caused by practices that once seemed like good ideas. The ends of the practices once justified the means, and now our water, air, soil, and our bodies are contaminated. Our wild ecosystems are collapsing, and we're facing the next mass extinction. We have to shift from relative risk decision-making to a precautionary approach. MOFGA fully recognizes that in order to build a more local, more organic Maine agriculture, we need to ensure that Maine farmers and farm businesses can make a comfortable living through sustainable management practices. We maintain that financial sustainability on the farm is inextricably linked to healthy people and healthy ecosystems. We recognize that many farmers have expressed concern about the breadth of the language in this proposed constitutional amendment. What will this mean for farmers who already have so many soil and water health practices built into their farm management plans and have to comply with significant regulations? We know this amendment will present many questions for how we can move forward safely and successfully, but we have to act swiftly and reframe our collective approach to creating new products, technologies, and industrial and agricultural management practices. This amendment will move us away from relative risk approach that has polluted our air, water, soil, and bodies toward a more precautionary approach that ensures safety before introducing into our environment. Thank you for your consideration of this important bill. We urge you to pass this and allow the people of Maine to show their support for a healthy Maine future.
Thank you so much. Are there any questions for Heather? I'm not seeing any. Thank you for joining us this afternoon. It's good to see you. All right. Last request for anyone left in the attendee space here to speak on behalf of LD 489. Raise your hand. In favor, Maggie Blake. Welcome, you're on mute.
Sorry. Senator Brenner, Representative Tucker, members of the committee. My name is Maggie Blake. I'm a Colby College student and I love Maine. Not being from Maine, I've been able to appreciate how incredible and unique the state of Maine is. There is nowhere like it. The rocky shore of Stockton Springs, the snow-covered Rangeley Lake, the breathtaking view off the top of Bald Mountain. Maine is the last of its kind. There is no other place with the breadth of wild wonders preserved and thriving. I am saddened by the development in my home state of Massachusetts. While not possessing the same beauty as Maine, the land is being overtaken with large warehouses, housing developments, and chain stores. This is a trend happening across the country. While you may assume that our environmental rights are protected, anyone I've asked about the subject has, they are not. There are no adequate barriers preventing careless out-of-state corporations from tearing apart the natural beauty that holds this state so strong. The Pine Tree Amendment is not radical, it is not abstract. We're asking for simple protections we should already have. I'm here because I am afraid. I love Maine's coast. I love the center of Maine that I currently call home, the beaches of Scarborough, the mountains of Western Maine. I don't want to imagine a world where I hike to the top of Bald Mountain to see factory smoke and deforestation. I want to be able to show my grandchildren the beautiful state my grandmother showed me. We have the power to protect our slice of the world. We can't control Massachusetts, we can't control New Hampshire or the federal government. We can do our part to protect our home. for all the hardworking men and women in Maine, for all those who depend on the Maine outdoors, and for all who love it. It is essential for our economy and it is essential for Mainers. I'm asking you to please seriously consider and vote to support LD 489 to safeguard the economy of Maine in the future. Thank you.
Thank you, Ms. Blake, for joining us. I appreciate your testimony. Are there any questions? I'm seeing none. All right. Thank you so much. All right. Are there any other folks in the attendee space here to speak for the bill in favor of 489? Going once, going twice. Is there anyone in the attendee space here to speak in opposition to the bill? In opposition to the bill, going once, going twice. And is there anyone in the attendee space here to speak neither for nor against the bill? Raise your little hand. I'm not seeing anyone. All right, last chance. Anyone who wants to speak on LD 489 in the attendee space, either for, against, or neither for nor against. Okay, I believe that closes our public hearing on LD 489. Thank you, everyone, for a solid morning of testimony. Let's take a 5-minute break and then we will regroup and we'll have our work session for LD 67, LD 69, and LD 390. So we'll be back at 1:40. Thanks.
I will say, Senator, that Haley is amazing. She did research in high school that graduate students wouldn't be doing. She's really, she was one of the sentiments that I did because she won an award for excellence. Great. You just looked at the future.
That was a good morning. All right. Thank you all for entertaining my need for a quick break. I appreciate it. Welcome back, and we will open up a work session. We'll start with LD 67. An act to assist in the restoration of Atlantic salmon. Deirdre, do you want to give us a quick reminder walkthrough of this piece of legislation so we know what we're talking about?
Sure.
Thank you.
So this bill eliminates restrictions on the total number of discharge licenses allowed to be issued, and it removes redundant language regarding the length of a discharge license issued for a Class AA or a Class A waters when that license is to assist in the restoration of Atlantic salmon and will return the waters to a state that is closer to historically natural chemical quality. The redundancy in that 5-year limitation on discharge licenses is because in Title 38, Section 414.12, it already limits the term of a discharge license to 5 years. So the department felt that that was unnecessary language. So basically the bill is removing redundancy and allowing the department to issue more than a total of 3 discharge licenses for the purposes of Atlantic salmon restoration. Just as a quick overview too, just some of the proponents of the bill, there were a couple proponents, no opponents, and no one testified neither for nor against. And proponents of the bill had stated that it would strengthen efforts to restore Atlantic salmon through water quality restoration in down east waters. And for many years, the department has licensed and participated in the liming of acidic waters through the addition of clamshells as a restoration action for Atlantic salmon. And the addition of liming agents, including clamshells, is an activity that requires a discharge license from the department. And that the initial language in statute was there when this was relatively unknown practice, but now it's pretty well known. And so they feel that they're comfortable removing those limitations.
Great. Is there any additional discussion? Representative Ziegler. Oops, you're on mute, Representative.
I'm sorry, I was going to move the ought to pass on LD 67, but if there's discussion, I'll step back.
We could put a motion on the floor and second it and then have discussion.
I second.
Okay. Representative Johansson.
Thank you, Senator. Could someone tell me what kind of discharge permits are not going to be issued? What kind of industry or businesses that would affect?
They're still going to be issuing discharge licenses. It's for putting in sort of clamshells or liming agents to bring acidic waters back to a more natural state. So the discharge licenses would still be issued under this. It's just removing the limitation that the department could issue no more than 3 discharge licenses for this purpose.
For discharging what, ma'am?
So liming agents, so they're using like clamshells, they're breaking up clamshells and putting them in the waters to bring the acidity levels back to a more natural historical level.
Thank you very much. That was helpful.
Representative Tucker. Oops, you're on mute, Representative.
When I first saw this bill, I was somewhat alarmed because the title seemed to talk about saving salmon, which was great. But then when I looked at the statute, it removed a strict limitation on the amount of discharge, the number of discharges that could be made into A and AA streams. And it seemed like a contradiction to me. But upon hearing the evidence and listening to Mr. Kavanaugh and the advocates for the Atlantic salmon, they've convinced me that this is not a threat at all. And in fact, having more discharges would allow, the use of the clamshell and the de-acidification of some of the streams. And so it seems like a great idea. And I now see the link between encouraging salmon and allowing a few more discharge licenses, which are under the supervision of the DEP anyway. So I'm definitely going to vote for this one. Thank you.
Any additional discussion? Do we feel ready for a vote? All right. Sabrina, are you ready for the roll call?
I'm sorry.
Yes.
I was just, if you wouldn't mind just giving me 30 more seconds to review Deirdre's note on this, which I just opened up. I'd appreciate it just to refresh my memory fully about this bill. It's coming back to me now, clamshells and all. Can I have like 20 seconds to? Thank you.
Sure.
Madam Chair?
Yes.
In the meantime, I see LD 67 and I see, what other, I don't see anything else from Deirdre. Deirdre, did you send another one?
There should be LD 69 and LD 390.
I have 390. I don't have LD 69. I just have LD 67. Maybe.
I haven't sent them because Dan said he's been sending them right before the work session started, but I can send those right now to you. So you should have them in your box in a second.
Yeah, it'd be nice to have them all up front, I guess.
You should have them all now.
Okay.
I'm good. Thank you for the courtesy.
Of course. Do we feel ready, committee, for the roll call? Go for it, Sabrina.
Okay. Senator Brenner.
Yes.
Representative Tucker.
Yay.
Senator Bennett.
Aye. That's a yes.
Representative Hanley. Absent. Senator Carney. Absent. Representative Bell.
Yes.
Representative Bloom.
Yes.
Representative Dudera.
Yes.
Representative Gramlich. Absent. Representative Johansson.
Yes.
Representative O'Connor.
Yes.
Representative Toole. Absent. Representative Ziegler.
Yes.
Nine yes, 4 absent.
Great. That closes the work session on LD 67. Now we will open work session on LD 69. Is there any information you would like to provide us?
Yes.
Great.
So LD 69 is an act to reduce duplicate permitting review for projects under the site location of development laws. This was a department bill presented by Representative Tucker. This bill increases the upper acreage limit of a structure subject to municipal review and exempt from department review and permitting from 7 acres to 10 acres under the site law. Under current law, just for the purposes of giving you a little background information, a structure is defined as buildings, parking lots, roads, paved areas, wharves, or areas to be stripped or graded and not to be revegetated that cause a total project to occupy a ground area in excess of 3 acres. Stripped or graded areas that are not revegetated within a calendar year are also included in the calculation of the 3-acre threshold. So under this, the bill has 2 parts. The first part, where it increases the threshold from 7 to 10 acres, is under the part that deals with municipal capacity. So if in under current law, a project of 3 to 7 acres, in this case, in the bill would go to 3 to 10 acres, is exempt for review under site law if located wholly within a municipality or municipalities meeting specific criteria as determined by the department and is located wholly within a designated growth area as identified in a comprehensive plan adopted pursuant to law. And then the second part of the bill deals with delegated authority for municipalities. And under that, under current law, a municipality can be registered by the department for authority to substitute permits issued pursuant to ordinance powers for permits required under site law for structures that are 3 to 7 acres. Again, this would move that from 3 to 10 acres. So that's the 2 parts of the bill. It's dealing with municipal capacity and delegated authority, expanding the upper limit of those projects that can be done by municipalities instead of the department. A few people, actually only one person testified in support of the bill. That was Nick Livesey from the DEP. There were no opponents, and neither for nor against was Rebecca Graham from MMA.
Is there any discussion about LD 69? Yes, Representative Bloom. Whoops, you're on mute.
I'd like to move ought to pass.
Is there a second?
Second.
Any further discussion? Not seeing any. I believe we are ready for a vote. Sabrina, are you ready for a roll call?
I am now.
Oh, wait, let's take just a hot second. Representative Toole's joined us. Representative Toole, would you like to introduce yourself before we go any further?
Oh, good. Thank you, Madam Chair. I'm Representative Will Toole. I represent the Machias area plus Lubec and Eastport.
Welcome. All right, and with that, we will call the roll for the vote on LD 69 ought to pass.
All right. Senator Brenner.
Yes.
Representative Tucker.
Yes.
Senator Bennett.
Yes.
Representative Hanley. Absent. Senator Carney. Absent. Representative Bell.
Yes.
Representative Bloom.
Yes.
Representative Dudera.
Yes.
Representative Gramlich. Absent. Representative Johansson.
I'm getting a little uneasy about all these yes votes, but I'll vote yes again.
Representative O'Connor.
I don't like Chris to feel left out. Yes.
Representative Toole.
Yes.
Representative Ziegler.
I'm still in shock. Yes.
Ten yes, 3 absent.
Look how much fun consensus is. Okay, I believe that closes our work session on LD 69. And now we'll open a work session on LD 390, an act regarding the mapping of shoreland zones. And I'll pass it to Deirdre for a brief reminder.
So sections 1 through 7 of the bill, it amends existing definitions of the following terms under the Mandatory Shoreland Zoning Act: coastal wetlands, freshwater wetlands, forested wetlands, outlet stream, and stream. It also adds new definitions under the mandatory Shoreland Zoning Act for the following terms: tributary stream and wetland. Section 8 of the bill adds further requirements for minimum guidelines for municipal zoning and land use controls adopted by the Board of Environmental Protection, including the use of clear and operable language that references widely available and best available data sets, specifically for modeling in a geographic information system and for enforcement purposes by municipal officials. The addition of defined terms of contiguous, adjacent, and sufficiently connected and other similar operational terms, the selection distances for use in geographic information systems and field surveys, and it excludes from the resource protection zone lots where the less than 2,500 square feet of the lot would be zoned as a resource protection. At the public hearing, 2 people testified in support. That was the sponsor and Rebecca Graham from MMA. There were quite a few people that testified in opposition, including the department, NRCM, Maine Association of Wetland Scientists, Maine Association of Planners, Marita, and then some code enforcement officer from municipality and a few other just people in the public. And neither for nor against was Shelley Norton of AvCog. I'm going to go back to a couple of possible amendments that were suggested in testimony, but I do want to bring up 2 points in the bill. In the addition, in the definition sections of adding tributary stream, that's a new definition that the bill is proposing to add. However, tributary stream is not utilized in the statutory provisions related to the Shoreland Zoning Act. So nowhere else is that term utilized within those portions of the statute. That term is used within the Chapter 1000 department rules, and it has a very specific meaning and is a zoning requirement. So there is some specificity in Chapter 1000 to how a tributary stream is treated under the law, but the definition that they're putting in statute is not utilized anywhere else in statute as it relates to shoreline zoning. So we generally, just as a note, don't necessarily put definitions in statutes unless it's utilized somewhere else in the statute. So that was one issue. And then another thing, and maybe somebody with more experience can clarify, but the bill I think creates can create some ambiguity, because it adds a separate definition for a wetland in Section 7 of the bill, but it's unclear how the added definition of wetland in Section 7 is meant to be interpreted in context of a specific wetland. So you have forested wetlands, freshwater wetlands, and coastal wetlands. So for an example, I think it'd be helpful. The definition of a wetland is an area inundated or saturated by surface or groundwater at a frequency and for a duration sufficient to support, and which under normal circumstances do support a prevalence of wetland vegetation typically adapted for life in a saturated soils. But if there is an area that meets that definition of wetland, but it's not depicted on the National Wetland Inventory as is required under the definition for freshwater wetland, it's unclear to me if that would be seen as a wetland, a freshwater wetland under this. So I think it's creating confusion because you have a definition of a wetland and then you have separate definitions for specific types of wetland. And those specific wetland definitions require it being depicted on a map somewhere. So if it has that wetland characteristic, but is not depicted on a map, then is it a wetland or not a wetland for shoreline zoning? And I think that may create some confusion under the current law and the current implementation at the municipal level of it. Just as a note, possible amendments, Shelley Norton from AvCog suggested maybe the creation of a work group to look at this issue more thoroughly and consider the range of mapping challenges that are present with the current law and find better ways of creating maps while maintaining the same level of resource protection. And Jared Woolston from Maine Association of Planners had suggested enacting language to allow field determinations within 100 feet of the map shoreline in lieu of formal zoning map amendments, and provide municipalities with more flexibility to enforce minimum shoreline zoning standards. By enabling local staff to perform field determinations to verify adopted descriptions of the shoreline zone. So it would be verifying the shoreline zone at the municipal level. And that's all I have. And I may have thoroughly confused you, so I'd be more than happy to clarify if necessary.
So we'll go in this order: Representative Tucker, Representative Johansson, and Senator Bennett.
I move that LD 390 ought not to pass. And after it is seconded, I would like an opportunity to speak to my motion and also discuss the possibility of inviting the sponsor and Mr. Livesay to join us and discuss the possibility of a letter to pursue this issue in a more informal way administratively, rather than by changing the statute.
Second,
The reason I have moved ought not to pass is because this is such a highly complex area. And it opens up, these changes that are being suggested open up a lot of settled practice in the field. And I was particularly impressed by the planning people who are actually in their hip boots out finding these wet areas. And but I think that there is an issue here, and I'd like to hear from Mr. Livesay and also from Representative Perry, if we could bring them on board.
Yes, we can. Sabrina, can you move? Oh, great. Here we go.
I have a question for Mr. Livesay.
Mr. Livesay, are you with us? Welcome.
Hello, you may be seeing the sun that's shining on my back, and it then hits my screen, and so I can't find the buttons to hit to get my audio and video going, but I think I'm here now.
One of the things that I would like to propose is that there be a letter from either the chairs of the committee or from the committee as a whole, from the ENR to the DEP, to you specifically, pointing out the issues raised by this bill and requesting that you and the DEP contact town and regional environmental regulators in the Washington County area and communicate with them what resources and cooperation are available from the DEP and other agencies to help the towns. Is this something that would be worthwhile in the practice that we're talking about?
Sure, I think some of the questions raised by this bill about what resources are available in the more modern mapping age are certainly valuable ones. I've done a little bit of looking around just on my own since the hearing on Maine Office of GIS, their webpage, to get a better feel for some of the variety of data layers that they have. I'm guessing that the folks in Washington County who work on this, some of them are leaders in GIS technology and probably know quite well what information is there and is not. But I think certainly one, what information is out there that might be available to towns that they can use today in a GIS format would be helpful. And I think also having discussions with some of the regional planning organizations would be beneficial too, in that for some of the smaller communities where I think resources are the primary concern here, there may be opportunity if to start thinking about some of these things collectively or regionally, and there may be opportunities to secure grant funding or use existing resources, more strategically, and think about shoreline zoning, not just in isolation, but in the broader context of some of the other efforts going on regionally with regard to climate change. So there might be opportunities to crack some of the funding nut here, if you will, just by putting shoreline zoning a little higher on the radar.
Mm-hmm. Madam Chair, may I address a question to the Representative Perry?
Yes, please.
Welcome, Ann Perry. How are you?
Doing well.
Could you tell us a little bit about what your fundamental concern is in regard to this bill?
Well, as it was brought to me, it really became a real difficulty for the municipalities to be able to do and understand what they were to be doing and how far they needed to go. And this came as a result of Judy East at the time, who was the director of the Washington County Council of Governments, who was working with the municipalities around this. So and I think as mentioned by Mr. Livesay, that these are small communities. These are communities with not very large populations. And they're finding it hard with the resources that they have, and also hard to understand what their duties are, even with the guidance of the Council of Governments, is how to do it. And that's really what brought around trying to do something with the bill that was produced.
Thank you very much. Madam Chair, I would propose that we vote on the bill after some discussion amongst the committee. I see some hands. And that after the vote, I would like to extend the discussion with Mr. Livesay as to the nature of a letter that could go to him and trigger some real department response. Thank you.
Thank you. Senator Bennett.
Thank you, Madam Chair. As usual, our House Chair is as judicious as ever. I think that that Representative Perry has raised some really important issues in presenting this bill. And in particular, I do think that we are not taking full optimal use of the geographic information systems across state government. Probably we're just getting a little window here in zoning and our area of environmental protection, but it may prove to be a really handy example for how we can get GIS maybe out and the rest of government out of its silos and start thinking about this asset, which I'm sure could have manifold deployments in effective, optimum ways across the scope of government. So if this something like this comes to pass, I just ask Mr. Livesay to bear that in mind, the learnings that you might have, and maybe we'd want the GIS people in here too at some point, and because it's just really easy for people to work in their own areas and not understand what cross capabilities there might be that would be in the public interest and save money and be efficient and get the job done better. So thank you, Representative Perry, for raising this, and I love the way that Chairman Tucker is choosing to take this. Thank you.
Thank you, Senator Bennett. Representative Bloom.
Thank you, Madam Chair. I want to just pick up on something that Mr. Livesay said, and it's something that I've been thinking of too since the hearing, that this is a larger issue, as Senator Bennett just raised. It's a larger issue in terms of how does GIS, how does that tool being used in Maine to the best of planning what I'm saying is that I think that to reach a broader audience and to have this issue fully looked at in terms of planning is that we should actually ask the Climate Council to consider it in their next report so they can do that wide interagency look at the subject and to see how they best can help communities with their GIS issues. Would you think that that'd be a good idea? Mr. Livesay?
Sorry. I do think that's a good idea and something that I'm certainly interested in. And I guess I'm also interested in, so that's sort of the big picture. And that goes to some of what Senator Bennett was talking about. And I'm curious, apart from any bigger effort from the climate group, just to have a few probably simpler questions answered for me about sort of the existing data sets that we have and what more might exist to deal with this, the wetland mapping piece. But those aren't mutually exclusive. One is sort of a smaller, more straightforward question. And then I think what you're talking about is a much bigger, more challenging topic, but certainly the role for GIS in addressing climate change is going to be key. I mean, it's one of the best tools that we have to take a look at things from sort of a landscape type perspective. But there are two things I think to keep in mind: is the GIS tool, and then the data that goes into it. And the challenge that we have in the shoreline zoning context, I think, is that we've got a great tool and the data isn't at the same level. And that's the challenge that we have.
Great, thank you.
Are there any additional discussion points? Are we ready for a vote with the motion that's on the floor, ought not to pass LD 390? I believe we are ready.
Senator Brenner,
Yes.
Representative Tucker,
Yes.
Senator Bennett,
Yes.
Representative Hanley, absent. Senator Carney, absent. Representative Bell,
Yes.
Representative Bloom,
Yes.
Representative Dudera,
Yes.
Representative Gramlich, absent. Representative Johansson,
Yes.
Representative O'Connor,
Yes.
Representative Toole,
Yes.
Representative Ziegler,
Yes.
10 yes, 3 absent.
Thank you, Sabrina. Is there any additional discussion?
Madam Chair, may I speak or ask a question of Mr. Livesay?
Yes, please do.
Mr. Livesay, could you help me please formulate a letter along the lines we have discussed earlier and send a draft to myself and to Representative Perry so that I could share it with the committee?
I'd be happy to do that.
Thank you very much.
Anything
That's
else?
all I have.
Excellent. All right. I believe that closes our public hearing on LD 390. Representative Toole, we could give you the opportunity to vote on the first bill that we had a work session on, LD 67, if you'd like to circle back around to vote on that with Sabrina while you're present.
Yes, sure. That would be great.
Okay.
Motion is ought to pass.
Okay. I will go yes.
Okay. Vote taken.
What a lovely afternoon of consensus, everyone. Thank you. All right, we have two more orders of business. The next discussion is on the language review for the St. Croix Waterway Bill, LD 203, with Dan. You want to go ahead and launch us into that?
Sure. I just sent out an email, which you should have gotten. So if you recall, LD 203 is an act to increase funding for the St. Croix International Waterway Commission. This is Senator Moore's bill. It was originally voted ought to pass, and then there was an issue with the inclusion of the current fiscal year in the bill. So it was reconsidered and revoted. Ought to pass is amended to make the proposal consistent with what's in the biennial budget, which we just had a hearing on. So in the document I just sent, you'll see the final ought to pass is amended committee amendment language, which the bill itself is a single section, which is an appropriations and allocation section. This will replace that in the bill. And the only change is that the FY 20 to 21 appropriation is removed. So these ongoing increased ongoing funding would start in FY 21 to 22, which is what's in the budget. There's also a formal fiscal note attached, which incorporates that same change. I can answer any questions anyone has about that.
This looks great to me. I will open it up to conversation. Representative Tucker.
So we took the vote already, and this is simply the implementation of the vote we took after reconsideration. Am I right?
That's correct. So
you're not looking for a new vote or anything new from us?
No, this is just sort of an FYI as we do our language reviews. In some instances, the committee will have seen a draft amendment, so the language is not a surprise. In other instances, language might be something the committee hasn't seen for the most part, and so it may be something we want to go through a bit more. Usually fiscal notes are sort of routine and nothing that is unexpected, but sometimes there are fiscal notes that are unexpected. And so the practice is to bring all of those items back to the committee for a brief review. And if there needs to be further discussion or changes made, then that could be done at that time, or it could be scheduled for a later date. So as long as no one has an issue with this, I will assume that we can move forward with it and get this to a point where it can be reported out of committee.
So how about a little straw poll? How are people feeling? Does everyone feel okay about this? Raised hand. Okay.
May I ask a general question, please?
Yes.
I'm a little bit concerned about having the OPLA summary and review 2 minutes before we open up the work session. Is there any way to avoid that kind of impact? Most of these bills I've understood well enough from the testimony and so forth so that I have no problem with them. But as cases come up where the text becomes important, I'm a little worried about getting the OPLA report 30 seconds before we're about to discuss, file a motion and vote. So I just would like a little background from Dan on how he feels about this, because I'm sure he's in a bind too.
Are you referring to the analysis?
Yes, the analysis.
Oh, well, I mean, in what I guess we could call normal times, we had the practice of never handing that out until the beginning of a work session. The reason for that is, well, in some instances, it's not ready to go until just before a work session, or we're waiting on some attachment that might be a proposed amendment. But the larger reason for that is there have been many instances where a work session ends up not being held, and we don't necessarily want that document out there if it's not going to be discussed and reviewed by the committee. So that's our general practice, is to not share those documents, regardless of whether we're doing electronic meetings or not, until the work session begins. In some instances, that's not a big deal because the committee already knows what they want to do. In other instances, we might read through the analysis in a very detailed way. It's it's up to all of you to how much you want us to go into detail on the analysis that we prepare. It's not something that we can always anticipate in advance. I think Deirdre and I could certainly discuss sending out the analyses when we begin a block of work sessions, if that's possible. But I don't know how much sooner than that we could commit to providing them.
I wasn't looking for a solution to the problem as much as an understanding of what the practice is and why. And we can all think about what we might want to request the committee do as a common practice. I'm not pushing for any decision right now.
And then we have one last discussion point for today on a draft letter that is going to be sent from our committee to the DEP that everyone should have received, and we're just looking for approval. And this is a letter that will address permitting around the New England Clean Energy Connect corridor. Yes, Senator Bennett.
Thank you, Madam Chair. The letter looks fine. I would like advice with respect to one word, and that is, and I want to thank the chairs and the staff for working on this. At the beginning of the second paragraph, it says, from your comments at that briefing, we understand this minor revision application has been accepted by the department, ... I don't know what the right word is, and maybe accepted is the correct word here, but there seemed to be a question outstanding that whether this was actually a minor revision. And I just want to make sure we're not, by using the word accepted, I'm sure it's a term of art and law, that we're not assuming that the department has ruled on that in our letter.
So I could jump in because I framed out the letter for Senator Brenner. I was originally going to write accepted for processing because that is, so when an application is filed with, I can certainly say the department, I'm not sure if it's true for any agency, the department reviews it to make sure that everything that needs to be in the application is in the application. And at some point, they will determine that it has been accepted as complete for processing, and they'll begin their processing on it. I understand they won't necessarily, in many instances, begin processing an application until they deem it complete. So that was what I was trying to get at with that language, is that it has been accepted by the department as complete and that they are now reviewing it. I can certainly try to fine tune that language. My understanding is that it was filed as a minor revision application. Whether or not any person believes the proposal is minor, I think that's the term of the type of application that's filed as a minor revision. So I don't think it presupposes the department's approval or disapproval of it.
Okay. Thank you. I again, this is part of an oversight function and has no legal bearing. I just wanted to flag it. You've thought it through, and I appreciate that, Dan. And the chairs, I want to say thank you to you both as well. Thanks. I would, and speed is more important here than one or two words. So I would, if you need a motion, I'd say please forthwith, but I don't think you do you?
Just a more or less a straw poll that everybody's comfortable with the letter as drafted.
Thank you.
Mm-hmm. So we will assume no further conversation means that everyone is comfortable with the letter, and we'll go ahead and send it.
Yeah, so I can sign for the chairs and I'll send it out this afternoon.
Thank you. And I do believe that that concludes our business for today, unless anyone has any other issues that I am missing on my to-do list.
Could I say something?
Of course.
I'm unaware of any divided reports out of this committee that are coming up in Wednesday and Thursday session. And in fact, I can't think of much that's controversial even, except there's going to be a lot of referrals. And Monday night, when the House calendar comes out, because I'm on the House side, I'm going to be going through all those bills that are on the calendar for referral and consulting with leadership on those bills that might overlap with other committees. So if anybody sees a bill on there, either your own or one that you're interested in, that you think doesn't belong in ENR, please let me know. And I'll look into it. I just wanted to let everybody know, we've got what, about 20 or 30 bills that are going to be referred off that calendar. And I just wanted everybody to know that's what I'm going to be doing Monday night. Thank you.
That's tonight, Ralph.
Yep, you'll be busy tonight. All right. And with that, I believe we are ready for a motion to adjourn.
Motion to adjourn.
Wonderful.
Second.
Thank you, everyone, for a great day. We'll see you all on Wednesday. It'll be nice to say hello in person.